Good morning. My name is Pippa Browdy. I serve as the Associate Dean for Academic Affairs here at the Alexander Blue III School of Law at the University of Montana. The University of Montana acknowledges that we are in the Aboriginal territories of the Salish and Kalispel people. Today, we honor the path they have always shown in caring for this place for generations to come. Welcome to the 40th anniversary of the Public Lands Law Conference. I want to especially thank all of the supporters and sponsors of this year's conference. And I have a special thank you and congratulations to the students who serve as staff and editors of the Public Lands and Resources Law Review. Your work reflects the values of our law school as we reflect on the history of public lands and how we can apply those lessons to the future of public and tribal lands. I hope that you have a wonderful conference despite the terrible weather. And it is now my pleasure to introduce Professor Michelle Bryan.
Good morning. It is one of my favorite times when we get to gather again and see all of the people who care so much about public lands and tribal lands, see alumni of the law school and gather together to have these important conversations. So how exciting is it that it happens to be the 40th time this has happened? It's a really big deal in my mind. And I, along with Professor Stark, are the faculty supervisors at the moment of this beautiful creation that Marjorie Hunter Brown and her students started so long ago. The first conference was in 1979. And about 10 years ago, we switched it from annual to biennial because we added a special lecture on water called the Jestrat Lecture on Water, and we alternate now between those two events and hope that you can engage in that event as well, which has been really wonderful to have a focus on that topic. And we had fun, we and the students, going back through some of the old agendas of the first conferences, which really highlight how much the journal has always focused on public lands, natural resources, and Indian law. And there's no other journal quite like it anywhere in the country. And at the very beginning, we had, as we noted last night, we had John Leshy here talking about wilderness on BLM lands. We had Charles Wilkinson. He was the very first speaker at the very first conference and a dear friend of Marge's. Professor Stark's going to talk more about him. He called Marge the guiding light and one of the West's leaders in Indian natural resources and public land law. So we're just caretaking her legacy and the legacy of her students today. And after her was Ray Cross, a renowned Indian law scholar, and we dedicated, we lost Ray Cross, but we dedicated a special edition that contains all of his collected works and celebrated him at a recent conference. We have talked in our all throughout these years and from the beginning about Federal Reserve water rights, which is a theme again today. We had the late David Getches talk about Indian lands and public lands. How are they similar? How are they different? We've talked about energy, grazing, mining, timber, and public access from the very first conferences, which comes up again today in our first panel. We had a whole conference about the Sagebrush Rebellion, which has reared its head again in various forms of late, and wildlife protection. And if any of these jump out at you as of interest, all of the journal editions are online and available, so you can go back through time and see who has written what on these important topics. So really excited to have a through line from the beginning to what we're covering today, pulling out those lessons and asking for the challenges of today. How do we take that wisdom and use it in new ways? So thank you all for being here. And I'd love to invite my colleague, Professor Stark, to celebrate a couple of our dear friends of the journal.
So in your pamphlet is a summary of us honoring both Nicole Ducheneau and Professor Charles Wilkinson. The first, Nicole Nikki Ducheneau walked on July 14th, 2023. She was a member of the Cheyenne River Sioux tribe and a first-generation descendant of the Confederated Salish and Kootenai tribes. She was a 2007 graduate of the University of Montana School of Law and a strong supporter of the Public Land and Resources Law Review, where she generously gave her time as a conference speaker. She last spoke at the conference a few years ago on the Dakota Access Pipeline. After Nikki finished law school, she was selected for a clerkship with the Montana Supreme Court, and she began her advocacy career as a Montana public defender, and then she moved on to defend tribal sovereignty and jurisdiction as a formidable and innovative litigator. She was also a devoted and loving mother and gave her time to her children and her family. Professor Charles Wilkinson walked on June 6, 2023. He had a remarkable career in the field of public land law, federal Indian law, where he wrote, taught, and advocated for the rights of Indigenous peoples and the environment. He was a graduate of Stanford Law School, and in 1971, he joined the newly formed Native American Rights Fund as a staff attorney and helped shape the organization's path-breaking advocacy for tribe. Professor Wilkinson was a dear friend of Marjorie Hunter Brown and helped start the Public Land and Resource Law Review and supported the journal throughout the years by both publishing articles and speaking at this conference. And he was a force in natural resource scholarship, a tribal advocate, and a leading Indian scholar. So we want to remember both of them.
Morning, my name is Sawyer Connolly. I'm one of the editor-in-chiefs of the Law Review. Thank you all for coming. Some few quick housekeeping things. Bathrooms, if you walk out this door, take a right and go down this hallway. There's bathrooms on your right as you go down the hallway, or if you go down the stairs, there's another set of bathrooms right there. Wi-Fi is the account as Grizzly Guest is the name, and you just input your email, and you can use the Wi-Fi. If you paid for lunch, we will have that at noon, but anyone, please, we'll have a keynote speaker at noon, so please come in and eat your lunch here. But if you haven't signed in yet, please be sure to do that for our records at the front in between sessions. I want to give a quick thanks to our sponsors, the law firm, the Weiss Foundation, the 2015-2016 Plurler Editorial Board, Five Valleys Land Trust, Parsons, Bailey, and Latimer, Beckfold Law Firm, Ferguson and Copes, the State Bar of Montana Environmental Section, and Indian Law Section, and Milo Dragovich, Dale, and Steinberg. Without their support, this would not be possible. Now I have the privilege to introduce the Principal Deputy Director of the BLM, Nada Wolf Culver. Director Culver graduated from the University of Pennsylvania School of Law. She then went into private practice in Denver, working for Patton Boggs, working on energy development and environmental remediation. As she said earlier, her path to the government was a bit winding. After private practice, she worked for the Wilderness Society, as senior counsel and senior director of agency and policy planning. and then moved on and spent just before the BLM time with the National Audubon Society as the Vice President, Public Lands and Senior Policy Council. And now she oversees the operations as second in command at BLM, and with that I'll turn it over to Director Culver.
Good morning, thanks for having me. I got assigned the topic of the future of public lands, which is really straightforward, very direct, and also I've had the privilege of following on after you heard from Don Leschi, who knows all the things about the past and future of public lands. So I'm hoping this will be a nice follow-on and discussion. And I thought one thing I could do is talk about how we're looking in more the day-to-day to get to the future of public lands that I think we all feel that we need so they can continue to be sustained, looking at their ecosystem resilience and their value. Being here in Montana, you all probably know the value of public lands. And what we've seen at the BLM is during the pandemic, a lot of other people discovered the public lands and none of them are leaving. So everybody loves the public lands, and that just adds to both the privilege and challenge of this. And before I dive in here, this is the Coxcomb Wilderness Study Area in Utah. So just a good example of some of the places where we're trying to continue to protect, and wanted to send the best from our director, Tracy Stone Manning. It tells you how much she supports this school that she sent me instead of coming home for the weekends to be here. So thanks for having me. For those of you who don't have all these numbers at the tip of your fingers, just I'm going to mention who the Bureau of Land Management is. We are the largest manager of land. We manage 245 million surface acres across the country, as well as 700 million surface acres, subsurface acres. So oil and gas, solar, mining, all of the things. We recently celebrated our 75th anniversary of what we sometimes, or at least I sometimes refer to as the Unholy Alliance. When the Bureau of Land Management was created by the marriage of the General Land Office and the Grazing Service. And I think that tells you a lot about how we started and the path that we've been on since then. The Land Office gave land away, and the Grazing Service also managed land for obviously grazing. And that 245 million acres is a really wide range of ecosystems. Obviously, it's concentrated in the West and Alaska, but you see, subsurface minerals throughout the country. And if you haven't been to some of the lighthouses, like the one in Florida, we actually manage one there. So pretty much every ecosystem there is, we get to. And the BLM's mandate is to manage for multiple use and sustain yield, topic of a lot of academic thinking and lawsuits. So hopefully you've covered a lot of that. The wonder of multiple use is it's everything from grazing to recreation to wilderness to energy development, ranging from fossil fuels to renewables to protecting natural resources, cultural resources, historic resources. And obviously we can't have all of those in the same place at the same time, but that's kind of been the overarching approach for many years. That's had some interesting consequences. And sustained yield is really the idea that we're managing for future generations so that the next groups of land managers and land users and public land attorneys, may I say, have all the opportunities that we all have to enjoy those public lands and make good decisions. So it's an elastic concept and a really truly awesome responsibility to work for the Bureau of Land Management, having advocated for a long time from the outside. So I thought I would talk a little bit as we look at Bears Ears about some of the thoughts that this administration has had, and really from day one, on the very first days of his action, President Biden issued a number of executive orders and also a memo that came to the heart of public lands, really a commitment to address the climate crisis. Addressing really what I think of as both sides of the climate crisis, right? How do we generate less greenhouse gas emissions, to stop making it worse, but also how do we make sure that our land is resilient and continue to function as the climate continues to change So that's really both within the bounds of a lot of things that the BLM does. The other thing that came up from day one from President Biden was an executive memo on co-stewardship and relationships with tribes, and really ensuring that was a centerpiece of this administration. I have the incredible privilege of getting to see Secretary Deb Haaland on a regular basis, and we're all pretty much Deb Haaland fans for all reasons, but it's really a privilege to work for her and under her leadership on all of these things, from climate to trouble and stewardship. So we are trying to weave together those very many elements of how we manage for multiple use and sustain yield to create a vision for the future. These lands are a great example of previous strife, right? They were created as a monument by President Obama, focused on tribal co-stewardship, focusing on threats from oil and gas and uranium. The monument was mostly overturned by, in an effort to overturn by the last administration. President Biden reinstated that monument. But again, it's a lot of thoughts of balancing conservation and resilience and tribal co-stewardship. And these are all parts of our FLTMA multiple use standard. And I think the other overarching kind of thought we've been operating under as we look at the future of public lands and how we contribute to it in managing for the Bureau of Land Management is that if we don't address climate and think about it, we can't really succeed in this mandate. Because these lands, many of them are arid, many of them, if you think about Alaska, are showing the very most early impacts of climate at rates that nobody expected. So if we're going to continue to manage public lands for all people, we're going to have to address climate in different ways. So I go over some of the different things we're working on, building on what the BLM has done before, and honestly, what I think we've learned along the way to try to make it more consistent, more accessible, more durable. So starting with renewable energy development, there was an Energy Act passed at the end of 2020. And part of that was a mandate to the Bureau of Land Management to permit 25 gigawatts of wind, solar, and geothermal on public lands. That is a lot. There was about 2 permitted before this administration total. So that's a lot. And that was from Congress, a bipartisan bill. This administration has committed, President Biden has committed to a carbon pollution-free electricity economy by 2035. And then we've seen additional commitments and efforts to make sure we're kind of speeding up renewable energy siting. And of course, that you can see here, it's a very scenic photo, but these do have impacts that we have to address when you put large wind and solar projects and geothermal on public lands. And then of course the catch is, if you put up a wind turbine in the middle of nowhere and there's not a transmission line, what have you done with it? So we're now looking at transmission across the West. And I always have said for many years, once you get a multi-state transmission line, everybody becomes an enemy because it's everybody's backyard. So those are some of our biggest challenges. And some of the ways we're trying to achieve that is we have these permitting goals. We're tracking our progress toward, we've made a lot of progress. And we're working to achieve that in a number of ways. So we are we updated some of our guidance. We're now updating our regulations for wind and solar leasing. And so some of the things that we have proposed in that regulation are codifying reduction in rents and fees. This is important for all of you FLTMA junkies. I hope there's some here that know that under FLTMA, we're required to get fair market value for the use of public lands. And that's a very good thing because we manage these lands for the American taxpayer. However, the Energy Act of 2020 said, well, yes, and you should do whatever you need to do to make public lands more appealing for wind and solar. Got a lot of feedback after the initial regulations were passed in 2016 that we were basically pricing public lands out, that it was very overwhelmingly costly to pay both an acreage fee for generation and a fee for rent. So the proposed regulations would address some of these fee reductions that we now have the authority to provide under the Energy Act of 2020. It provides discretion on where and when we hold competitive sales versus issuing rights of way. And it codifies this idea of prioritization. And this, I think you'll see, is a theme for how we're trying to manage all types of energy. Put it in the right places. Look for the places that have less conflict and better resources, so that we're both generating energy when we are deciding to turn public lands over to companies that are here for profit. And that's good for the American taxpayer, but also making sure we're keeping in mind this multiple use mandate and that responsibility. Two pretty creative things that we have going in this rule that I did want to flag is an incentive for domestic content. And we are looking at giving a reduction in how much a company might pay if they're meeting those kind of Buy American standards for construction. And then we're looking at an incentive for union labor. President Biden has been really clear on his commitment to providing union labor. You've seen him recently supporting various union activities. So we're looking at how we do that at the BLM. And one way we're looking at doing that is an incentive for using union labor. If you commit to that, you can get a reduction in how much you pay to develop on public land. So those are things that we got a lot of input on. We're currently working on that rule and hoping to get a final rule out in spring of next year. The other thing we're doing is updating our solar programmatic environmental impact statement. For all of you who I assume are also really excited about legal processes, this is a good one. Coming soon to a federal register near you. In 2016, the Obama administration looked at standing up a solar program because we were getting a lot of requests to do utility scale solar on public lands. It looked at the 6 southwestern states only. What we've learned since then is the industry has gotten better. They don't need as much land. They don't need to scrape it clean. They don't need as much room. So, and also that, you know, we're suddenly permitting solar projects in Wyoming. So this EIS is going to look at solar across the West, and we hope to get a draft out in the coming months to look at what's the right way to do that. What's the right way to continue building on the original solar vision, which had zones where we incentivize solar, exclusion areas where we didn't. So again, that's being better. Wouldn't be good to talk about energy without talking about oil and gas leasing. We have a proposed rule to update the oil and gas leasing program. Comment period closed recently. Over 200,000 people provided their thoughts. So thanks to any of you who did that. We are aiming to finalize that rule also in spring of next year. Just some details on this one. These regs have not been updated since 1988 in a comprehensive way, although many aspects of the oil and gas regulations that pertain to the fees that oil and gas companies pay to develop on public lands and for bonding have been in place since the 50s and 60s. So safe to say the time had come for some of this. Many of the fees and rents and royalty rates, which have been the subject of numerous reports from the Government Accountability Office, Congressional Research Service, and others, have indicated that this is what's called a high-risk program, and also that what we charge is hardly out of date, that we need to do a better job of managing for risk. So we're doing, I think, as many things as humanly possible with this, and while having a functional regulation. So really we're updating to make sure we're getting a fair return for the American taxpayer, because again, these are owned by the American people, and ensuring some responsible development where we're looking at it. The Inflation Reduction Act, which was passed last year, took a lot of this off of our hands and increased minimum bids and royalties and so forth. It got rid of non-competitive leasing, which was seen as one of the ways that we were seeing a lot of speculative leasing. If you can just put in a bid of $1.50 an acre for 1 million acres of public land, why not? You know. So that, I think, is something we've all been focusing on. We're also looking at increasing bonding rates, which were not subject to the Inflation Reduction Act. One thing I want to mention, and I won't go into all of the core details of it, but happy to talk about it, is the other thing Inflation Reduction Act did is tie renewable energy to oil and gas. The Bureau of Land Management cannot issue new approvals for wind and solar on public land unless we meet certain amounts of oil and gas leasing in the previous year and quarter. So these two things are linked together. To do one, we have to do the other. So now we're doing some very interesting calculations, math can be hard. But you know, we're doing it and making sure that we comply with that. Nonetheless, every time we issue a right of way for wind and solar, we get a call. Are you sure you're meeting the requirements? Newsflash, we are. But that was really an interesting part of the Inflation Reduction Act. I mean, a lot of changes that have been focused on for years by people looking at this program, but then also tied renewable energy to it. Some of the other quick highlights, we've clarified signboards on lease suspensions. You know, the BLM has leases that have been suspended for 40 years. No one, I don't think, has the records of why at this point. They should end. Federal leases are 10 years long. That is longer than any state, any private lease, anybody else. If we're going to have them that long, we need to know if we're extending them. Permits to drill have 2-year terms, again, longer than most states and private, but we have an opportunity to extend them for 2 years right now. So most APDs, authorized applications for permits to drill, are approved basically for 4 years. We're proposing they can have a 3-year term without extension. And again, we've updated overall the competitive leasing process. One of the things that's been subject to a lot of swings over the last few administrations is whether the public gets to comment on oil and gas lease sales. We're pretty sure that's a good idea, since again, the public is the owner of the public lands, oil and gas resources. So we're codifying how the public would be engaged, how environmental analysis would be done, and we're codifying preference criteria. What this says is we prefer leases when we are evaluating proposed leasing to be in areas that are more likely to produce energy, but also in areas that have existing structure and existing development that ensures we have a better chance of capturing methane, for example, of the existing infrastructure. But also we prefer to keep away from higher conflict areas with recreation, with tribal values, with wildlife habitat. And we requested input on how we might address greenhouse gas emissions. This is something that we currently addressed in the NEPA process when we decide if land should be open to leasing in land use planning, when we look at whether we look at the impacts of leasing and the impacts of permitting. So we've asked for input on that right now. The proposed rule doesn't change. So thoughts continue to be welcome on that. When I really wanted to address the proposed public lands rule, these are some public lands in Wyoming. It's a really cool event where we run the red desert. If you'd like to find out, it's very long. It's pretty cool. And this is not an update of an existing rule. This is a new section of regulation, so it'll be pretty exciting because we'll see it in the Code of Federal Regulations, and it wouldn't have been there before. I don't know, these things make me feel like I'm doing something exciting. And we have regulations on renewable energy, on oil and gas, on rights of way, on coal, on geothermal. You name it, we have it. We don't have grazing. Off-road vehicles. We don't have specific regulations on conservation as a concept, as a framework. The BLM has lost a number of cases over the years where the agency took the position that conservation wasn't part of multiple use. Not listed, not part of multiple use. I think that BLM is zero for however many on those cases. And so it felt like, again, time to give our folks in the field some good framework for how to manage for conservation, which in the context of this role, we're really focusing on ecosystem resilience and looking at conservation defined for this purpose as protection and restoration. One of the many multiple uses under FLIPA. So not new, but providing more structure, providing more tools. Again, we got input from over 200,000 very passionate people, and we're working to address those comments and issue a rule early next year. So a few highlights from that, more than a few, because this is one of our biggest undertakings, fair warning. So again, we're working on implementing the FLIPMA direction. How do we manage for multiple use and sustain yield? Focusing on ecosystem resilience, and it kind of has 3 elements: restoring degraded habitat and degraded lands, ensure we're informing management decisions with science and data, including indigenous knowledges, and protecting intact landscapes. We also are asking for input on Executive Order 14072, which, if you haven't read it, relates to mature and old growth forests. You might not think of the BLM as matching a lot of trees. We have some in Oregon and California, but this rule, this executive order directs us to inventory and come up with management approaches for conservation of mature and old growth forests. The majority of the ones for the BLM that you'll see are pinyon juniper woodlands. So those are incorporated in this executive order, so we're looking at that. And one of the things we're considering is addressing that more explicitly in the public land rule. So we asked for input on how that might fit into this overall structure. So just a few quick points on these highlights. The restoration aspect of this, again, the Inflation Reduction Act and the bipartisan infrastructure law have given an incredible amount of funding to restoration. So it's very timely that we give our land managers direction on identifying and prioritizing lands and restoration for land and waters for restoration. So we're asking that in decision-making and land use planning, we identify those priorities. We have included a tool here that in the proposed rule, we call conservation leasing. The idea here is you could issue a lease to a third party to conduct restoration or mitigation on public lands. This allows the public to come in and do restoration projects and ensure that while we're doing those projects, if the land isn't already being managed to focus on that, we can focus on it. Hopefully it'll align with these prioritized areas for restoration. But again, it gives us a way to ensure that, as our director likes to say, it all gets time to take root, which physically is an issue for us. And same with mitigation. Compensatory mitigation is a way that somebody who's developing on public lands addresses unavoidable impacts. And for the most part right now, the BLM has a very hard time getting folks to commit to do compensatory mitigation on public land. So you might have in the desert a solar project that harms desert tortoise habitat. And the Fish and Wildlife Service, or for example, the California Fish, Wildlife and Parks would say, well, we don't know what you're going to do next, BLM. Why would we put that restoration money, that compensatory mitigation for supporting additional habitat on public lands? We don't know what you're going to do next. So we've built a model over the years working in California, but the idea here would be, for example, a wildlife, Fish and Wildlife Agency or Game and Fish Agency could hold a lease to help with that compensatory mitigation on public land, so that the public lands users, all of us, don't lose that use forever and have benefit. And that's some of those highlights. I would say that the most universal comment we probably got on the public lands rule is that conservation leasing was not a useful term. It was very confusing to use the word conservation a lot. But people like the concept, but the title was not that popular. So responsible development, here, if you've studied grazing yet, right now we use landscape health standards and guidelines for grazing. We identify what that standard should look like across different ecosystems. And if an area is not meeting what it should look like, we're supposed to take action before permitting more grazing. One of the complaints we've heard from the ranching community for years is, why just us? So I'm not sure if this was exactly what they had in mind, but what we decided to do is apply it to everybody. So we're going to apply landscape health standards across the public lands, and we're looking at doing it on a bigger scale, which hopefully will allow us to get it done faster, because this has been one of the biggest challenges. These are the practices that we've seen, for example, at the Forest Service and other state agencies. And we're looking at ways to use the rule, as I mentioned, to help us balance development with other uses like recreation. And we have a mandate in the rule to avoid impacts that degrade land health and justify a decision when those impacts are found to be unavoidable or approving actions. Finally, protecting healthier landscapes. Again, if we're going to maintain wildlife habitat, migration in the face of climate change, overall ecosystem function, we want to make sure we're identifying places that are already functioning and can be prioritized to keep that going. We have an approach in here to identify areas for management for their intactness, to work with local communities to identify those, and to ensure that we are incorporating that into our decision-making for product. And finally, as part of this, we are updating our decision on areas of critical environmental concern. This is the one designation that is unique to the BLM. It is in the Federal Land Policy and Management Act. We're directed to prioritize it. The manual that addresses ACECs is from the 80s. It's very hard to find a copy. It's very hard to read. And it's time to update it. And we are working on that now. And I think we're looking to give consistent direction to land managers so we can all look at how we actually make that commitment to prioritize this designation, which can address everything from recreation to historical resources to science, actually meaningful. So again, final pillar of this is supporting tribal culture. This is something that has been a huge commitment of the administration. You see it in the monuments that are designated, you see it in many different aspects, that the rule really highlights the importance of tribal consultation and engagement when we're managing for ecosystem resilience and looking at opportunities for co-stewardship when we designate areas for intactness or ACECs or issue leases. And we think this would be the first regulation to go ahead and define indigenous knowledge, which in the current draft manuals is now, that the department's working on is now indigenous knowledge it's now plural. But in our role at the moment in the proposal, it's this. But the idea here is to identify that high quality decision making and high quality information which we're required to use includes indigenous knowledge. So we can make sure it's informed by all of these. Alaska, everything's happening in Alaska. So we can talk about more of those, but we are doing a lot here. As I noted, it's the place we're seeing the most impacts from climate change. And we're still addressing issues from the previous administration, updating the direction in the 2017 Tax Act to stand up an oil and gas leasing plan in the program in the Arctic National Wildlife Refuge that requires us to have another lease sale by the end of 2024. Supplemental analysis is out for comment now on that, as well as the Ambler Road, which would provide access for mining throughout a huge swath of Alaska. Again, we're looking at that as well. And we are revisiting public land orders that were almost issued at the end of the last administration that would open up 28 million acres across Alaska that are currently withdrawn to mining and leasing. And so we're doing a refresh of those. And we then have some newer initiatives, land use planning initiatives, and also a rule to manage special areas in oil and gas leasing in the National Petroleum Reserve, Alaska, which is currently open for comment. So we have 3 or 4 things. If you all want to work on comments, would love it. This does always come up, America the Beautiful. This is a commitment that the administration made to be part of the effort to restore, connect, and conserve 30% of lands and waters by 2030. Obviously, it will not all be on public lands, but this is an overarching administration effort that's focusing again on locally led and voluntary conservation. I just would note here that conservation in this context has its own definition and effort, and it's really a continuum of approaches of what we all, often refer to as conservation. If you haven't signed up for the monthly updates, they're pretty illuminating on how far ranging these ideas are. The last one, for example, talked about new wildlife refuges that were designated in Wyoming and Tennessee, the standing up of the Indian Youth Service Corps and their associated projects, and funding wildlife crossings. So it's really a pretty broad effort where we're trying to provide funding and support these kind of efforts. And finally, something near and dear to my heart, land use planning. This is where the rubber meets the road for the BLM. This is the Oregon Mountains Desert Peaks National Monument, where we are just starting a land use plan for the monument. And BLM land use plans can last 30 plus. We have some that are probably 40 years old at this point. And this is the way that we make decisions on what lands are open for what uses, what places are managed with special management, how we can really support co-stewardship, how we can support connectivity. So we do have a lot of land use planning efforts coming out right now. And that's another way that we can make sure that our efforts, our commitments to the public lands are durable. And so you'll see that. Again, I mentioned Oregon Mountains, Desert Peaks. Can't not mention everybody's favorite bird. It's mine, the greater sage grouse. We are updating conservation plans across 10 states for this bird that continues to survive despite some incredible challenges across the West. And also it's a pretty awesome dancer. So again, managing public lands for the future. We have a vision, a goal, an action. We're trying to get to success. For that, we need the BLM to function. We are really working as hard as we can to handle what happened in the last administration. We lost hundreds of people. The BLM headquarters was dismantled and sprinkled around the West. So we are making a lot of progress, both hiring people back and ensuring that we will support them going forward. But we need the BLM to work. We kind of need all of government to work We need advocates and partners. So we need to hear from you all. We need you to work with us on all of this, and we need what I would call watchdogs. So, if we have spinach in our teeth, tell us. We might not know it's there. There's 245 million surface acres. We might not know about that spinach. And it's really important to get both the support and the substantive helpful thoughts on what we might do now. So, the long view, couple of examples. This is the Carrizo Plain National Monument in California. This is a national monument. It has really cool stuff like Kit Fox's, the San Andreas Fault, but it also has historic ranching buildings that are part of the monument. It has a gigantic transmission line going through the middle of it because it's BLM land. And it just gets to all of what we're thinking about. And I think about it in Montana, the example of the Upper Missouri River Breaks National Monument, that backs up on our Highline planning area that is very much more traditional multiple use oil and gas. And then it all backs up on the CMR, right, the wildlife refuge. So we're all trying to think of the long view. How do we manage all of that together so we can continue getting there, getting to what we hope for the future of public lands, which is people are engaged and people are appreciating public lands, but keeping that part of the climate solution going forward, because we really need that. Public lands provide part of the climate solution on both sides, but they also provide livelihoods for people, and they're also just a vital part of people's lives. So just trying to make sure we actually accomplish all of those things. So this is my final pitch to stay involved in public lands policy, because it's just getting more and more important and more high level, high value for our country. And as mentioned, I did have a little bit of a long and winding road to get to work on public lands, but I'm never going to stop now. And so you can work on it in the government, you can work on it in private practice, you can work on it at the BLM, work on it all the time, or anywhere else. So thanks for having me, and we'd love to take some questions.
About 15 minutes for questions. We just have to do a quick mic swap.
Yes. I'm not going to just yell.
Well, you can. You'd like to try.
It's early in the morning.
Just make sure that it's captured.
No, I'm happy.
Good morning. You talked a lot about landscape health. Excuse me, from the perspective of the legislation and regulation side, but my question is more on the compliance, permittee compliance and enforcement side, in particular, in light of Bundy 1.0 in 2014, directly with the BLM, and Bundy 2.0 with the Fish and Water Service, and how that has affected the enforcement side. And also the agency culture. I would imagine it'd be very difficult for agency personnel to even engage in enforcement at this point in light of those events. Can you speak to that?
Yeah, I probably can't address ongoing legal disputes or bad things just disappear. But I think we are trying to support the BLM enforcement across the West and make sure that we can do a better job. We have inspection and enforcement efforts across a lot of different parts of the mission. I think that's a very sensitive situation there. We have been making progress with other parts of the grazing program and trying to make sure we're doing a better job of enforcement and working with landowners and also permittees to make sure we're doing that. I don't really know what I can say about the Bundy situation that would be helpful right now. But it's certainly fun center to make sure people are compliant.
We have a question from Zoom. How does the Supreme Court's kneecapping of the EPA affect your mandate operations and initiatives?
Well, we're not the EPA, so there's that, I guess. I think we are watching all of the cases at the Supreme Court and the questions about agency authority and the scope of our of deference, et cetera. So right now, we're trying to make sure, extra sure, that we are tying our work to our mission. There's been a lot of litigation over the years on what the mission of the BLM is and where our authority is. So we are keeping all that in mind. And, hoping we are staying within a good balance. And of course, also one of the reasons we do so much public outreach is to try to tamp down people's feeling that they need to sue us. So we have some optimism based on the comments we got on these regulations that we're generally headed in the right direction, both legally and as a matter of policy.
So what is the status, the logic and the moral reasoning of moving senior agency representatives from Washington to offices that are down the hall from the mining companies they're supposed to be regulating?
I'm not sure what you're referring to, but we have people all over the West, and our senior leadership is in DC, except for our Western headquarters in Greenwich. That's what you're referring to? Is that what you're referring to?
Yeah, I'm referring to it in the same building as the mining representative.
So at the time, in the last administration, there was a commitment to moving headquarters out of Washington, DC. The stated rationale was that the BLM needed to be more in the West. 99% of our people are already in the West. So I think that did not work out as well as had been hoped, because the vast majority of people who were supposed to be relocated were not relocated. They left the agency. So I can't speak to that rationale. I can just tell you what was said. I can tell you that Secretary Holland and our director have committed to having our headquarters back in Washington, DC, so that we can engage with Congress, so that when people come to DC to visit their congressional representatives and see other agencies, we're there too. And it's been generally successful. We are maintaining the Western headquarters of the building that you mentioned. We have a lease there. And the people working in that building are focusing on recreation and visitor services and outreach to partners. We're trying to make it as functional as possible. And just to say we don't buy that ration, obviously.
Good morning. Thanks for coming on to talk to us. And I just have a question about your role. It sounds like most of your career you spent as an attorney and advocate on the outside trying to push for a change. And now that you're within the government, can you kind of help us understand kind of the challenges that you're facing now that maybe we wouldn't as practitioners kind of still on the outside appreciate, and if any of those were surprises, and then any advice that you have for us now that you have this inside knowledge?
That's a great question. I get asked at the BLM a lot. What surprised you? Mainly surprised that there were so many more acronyms I didn't know, which is the saddest part of the surprise. I guess a lot of it would be to reiterate that when you're putting in really good ideas and substantive ideas that are kind of, the more functional they can be, the more they take into account the way the BLM already works, so that you're not going from here to here, like steps. Those are the ones that are easier to start implementing. And I would say that all of those ideas are thought about. I was really pleasantly surprised to see how the process works, that, the BLM really does get all the comments and really work through them and really think about, oh, should we make a change to address this? Or, oh, that was a good idea we hadn't thought of. So, I can't speak to every other agency, but I do see it. And so I would say that those are not falling on deaf ears. It might seem like it because you're setting, regulation, for example, you upload something to regulations.gov, but I would say that's really helpful. And then I do continue to think that it is really helpful to meet with the agency in the field. And getting to know your local land managers, or even if they're not your local land managers, showing up is helpful, because as I mentioned at the beginning, the history of the BLM is being kind of a service agency for grazing for land that turned into oil and gas, that turned into mining. And the more that they see these other folks, the better. We have some really good partnerships going now with advocacy groups from all ranges of the spectrum. And I think that's been helpful. And also, I would say when things seem delayed, it's not because, not often it's not on purpose. It really is getting delayed by going through layers and layers of bureaucracy. I would just say, nobody's offended going from private legal practice to nonprofit. I thought I'd hit the top level of bureaucracy and group decision making, and oh my goodness, that was a very hard culture change for me. There's even more. Obviously, it should have seen that coming. If you're one agency in the Department of the Interior, in an entire administration that is committed to taking on climate change, tribal co-stewardship, all the things. And so that was a little bit of a surprise, was how much it was an all of government situation, which is great, but also it's not as allowing for as quick a movement as you might want to have. So hopefully that means our actions will be more long lasting.
I just wanted to say I really appreciate your presentation. It's obvious that you really care about the work. We appreciate that. And give Tracy our best when you get back to DC. I was wondering if you could tell us, give us, I guess, your perspective on how the tribal advisory management board is working in years, what's going on down there, and just how that's kind of unfolding from your perspective of that. It's had a pretty difficult start in history with administration changes, but it'd be great to hear your view of the world perspective. I think
Sure. It has been a hard start for the commission. Certainly, they were in the initial proclamation to stand up the commission, and then it never happened. That was a priority right away for this administration to get the commission operating, but also to immediately get a cooperative agreement in place so that all 5 tribes could sign this agreement with the Department of the Interior and the Department of Agriculture for management of bears ears. So we really tried to start that out with very specific commitments to, before we make a decision, we will let you know, you will come to the table. So I think that was a really great start. And then we got into this whole land use planning process where we're trying to make a land use plan for a very large national monument with 2 agencies in southern Utah with 5 tribes. And just because there's one commission, that doesn't mean everybody has to agree on everything. And so I think that's been, what's been amazing to me is how down in the weeds everybody is. And that's also, it's been amazing to see all the input, all the thought on the level of detail that the commission wants to get engaged with. And I think some of the harder things have been where they've asked for something we don't have the ability to do, and trying to make sure we can explain that in a way that doesn't undermine the trust we're working so hard to build. I think we were all really honored that they signed an agreement with us, and want to honor that commitment. And so we don't want to go backwards on trust. That's probably the hardest thing. Is while this monument has a lot of commitment to tribal co-stewardship, there are also public lands. So that balance is I think going to continue to be a challenge. But I've just been really impressed with the commission's willingness to find the time, to have tribal leaders come and spend time with us on land use planning. It's really amazing. It's set a very high bar for everybody else, co-stewardship. So hoping we can make sure that not everyone feels they have to do that.
Thank you.
Yeah.
Hi, it's good to see you again. You referenced a little bit earlier some of the work that BLM is doing on recreation, which is really exciting. I'm happy to have been a part of it. I'm wondering if you can give some perspective on this rebuilding phase of BLM for recreation, conservation, national conservation lands, and what it feels like to be in the Department of the Interior with a vast public land portfolio, recreation responsibilities, conservation responsibilities, and not be the National Park Service.
Yes, I didn't start with that slide, but I feel like when I go other places, I often start with, we're not the Park Service, we're not the Forest Service, we're not the Fish and Wildlife Service, we're everything else. So I think this rebuilding phase has been a chance to really look at the role that we play in recreation. As I mentioned, it's been expanding an incredible amount. One of the harder things is when you look at the amount we have in our budgets for managing recreation per person compared to the Forest Service and the Park Service and even the Fish and Wildlife Services. It's orders of magnitude. So we started this recreation blueprint, working with our newly stood up BLM Foundation, which is very exciting also because we were the only big agency that didn't have a foundation that could raise money and help us. So that I think is going to be a really great partnership, a focus of the foundation. We're really trying to look at how we support recreation because a lot of the people who joined the BLM in the last even 5 or 6 years, they are getting to it not through experience working in an oil and gas company or working with a rancher, but through their love of recreating on public land. So I think it is actually also changing a little bit the character of our staff. You hear these, and they are not, confirmed, but we hear these interesting complaints like, I wanted to propose a project there, and the person at the BLM said they knew that area because they rode their ATV there, or they hiked there. Is that a problem? And it's like, we're all doing our jobs. But you see that people are seeing this broader value of public land, and it's not a problem, but it's also great that people come because they love it. And that's really what we're continuing to expand that work. And hopefully the blueprint will help us do it smart and smart.
Hi, can you talk a little bit about the appropriations process and BLM's conservation programs? And if those programs are receiving the money that they need to achieve their goals that the administration has?
I'm probably not the best person to talk about the appropriations process. And also we are, one of the challenges, we're not able to kind of lobby Congress for funding. But we do contribute to the president's budget, and you'll see there our view of what we need for these programs, and you can look at the delta between that and what we're getting, and it's a pretty big delta. So the monuments are a great example. The president comes and designates a new national monument. We haven't gotten new funding necessarily for those lands, so we're now shifting around to figure out how to do it. So it is one of the bigger challenges of conservation, but also something we're hoping to see continue to shift and as these programs get higher value. An example of Bears Ears, the Intertribal Coalition has received a lot of philanthropic funding. So that's been helpful, I think, to support tribes. But that's the other, there's a big nexus right now between our conservation work and our tribal stewardship. And one of the biggest challenges we do have is tribes saying, well, that's great that you want us to help you manage it, but we don't have people. Can you help fund us? So it's become a huge focus for, I think, everybody in the federal government. If we're going to do this, how do we provide funding? Thank you.
Great, thank you.
Good morning, my name is Brian Brammer. I'm a managing editor for the Journal, and I'd like to welcome you to our first panel today. And I'd like to thank the State Bar Environmental Section for sponsoring this panel. We are here to discuss the access conundrum, defining rights and defining public. As you've heard from our earlier speakers, and we'll hear, there are a lot of stakeholders in every public lands issue, so it's becoming increasingly difficult to balance competing uses and competing interests. With us today, we have Professor Lauren Van Schilfgaard from the UCLA College of Law and Director Martin Nye at the W.A. Franke College of Forestry Policy Center, and he's also a professor of natural resource policy. And our moderator is Professor Kekik Stark, right here from the School of Law. Thank you.
Thank you. Thank you for having me part of this wonderful celebration and symposium. I want to first begin by acknowledging two people in the field that played a role in previous symposia and that we lost this year, and two people that were incredibly kind, thoughtful, and inspiring to me, Professors Charles Wilkinson and Professor Raymond Cross. Crossing the next meridian, Frank's Landing, some of the literature of Charles Wilkinson is why I decided to do public lands for a living. And Raymond Cross was just the most thoughtful, kind person to me as a young scholar. He essentially wrote when I was starting to get in some trouble 21 years ago in the old school of forestry. He wrote a letter to my dean to tell him, let Nye do what he wants to do. So they're just wonderful people. I also wish to acknowledge just how multifaceted is our panel topic today, access. So just to be clear, I'm going to focus on one small part of the access issue and try to make some connections between contemporary disputes about access to federal public land and wildlife in Montana. So let's set the stage first. Here in Montana and across the West, disputes over access to both federal public lands and to state fish and wildlife are a symbol and surrogate for something far bigger. For background, let us consider two contemporary conflicts. The first is the loaded question of whether the public has a lawful right to access its public lands, including at the infamous checkerboard corner separating not time and space, but public and private sections of land. The big case here, Elk Mountain Ranch, Carbon County, Wyoming, where 4 hunters crossed such a corner, swinging first their feet and then a ladder through airspace and private property owned by Fred Ecken, a most wealthy owner of the 22,000-acre ranch. Criminal and civil charges, and most recently a decision by the Wyoming District Court in Iron Bar Holdings, ruling in part that Mr. Eshelman violated the 1885 Unlawful Enclosures Act by preventing lawful passage to federal public lands. The decision has been recently appealed to the 10th Circuit. Case 2 is here in Montana, one of several conflicts related to elk management in the state. The United Property Owners of Montana, UPOM, is challenging the Department of Fish, Wildlife, and Parks for its purported mismanagement of elk in the state. Among other things, UPOM wants to drastically reduce elk populations by 50,000 in parts of Montana and give private landowners hunting and commercial-like privileges and opportunities that are not provided to the public at large. Essentially tying management of wildlife to ownership of land. So the question is, why now? Why so many disputes about access to the some 9.5 million acres of public lands that are so-called landlocked, to conflicts over access to fish and wildlife, like the UPOM lawsuit? Of course, it's part artifact of the crazy mosaics of federal public land that we find throughout the West, including the infamous checkerboards, and all of the so-called transboundary issues that cross these property ownerships, from invasives, fish and wildlife, fire, and so forth. But most certainly, part of the diagnosis must be also the profound socioeconomic shifts in Montana and beyond, including an influx of out-of-state wealth and concentrations of land ownership, and with it, changing notions of what it means to own property. Shout out to Jill Belsky, who's in the audience here. An old article, and still, I think, one of the most insightful about how some new people to Montana view ownership. We are very much in a new Gilded Age. And like that profile in these 2 wonderful new books, there is an enduring, baked-in tension in public lands between private rights and the public interest in federal lands and wildlife management. As for the federal land system, we have an arrangement defined by private use of public lands, from mineral leasing, commercial permits, to grazing leases. Should not the public then expect reciprocity in return, like responsible, managed access at the corners of public and private? How should we, for example, consider this position on corner crossing by the Wyoming Stock Growers Association? We enjoy the privilege of grazing permits on public lands, expectations of moving livestock across multiple ownerships, but to simultaneously take such an absolutist view of private property in the corner crossing case. Or consider this, Mr. Eshelman, owner of Elk Mountain Ranch, and so vehemently opposed to legs and ladders crossing his private airspace. Well, it looks like, from what I understand, he runs livestock on public lands, paying $135 an animal unit a month to run his private livestock on public lands that he wants to exclude the public from accessing. So if I had my way, every beneficiary of public lands would be required to ensure that the public and free roaming wildlife has a right to access its federal public land, a term and condition of the lease, permit, and or contract to operate on the federal estate. I put it right here, right underneath the terms and conditions. I emphasize this to make a simple but often neglected point, and that is such a public/private system can only work with reciprocity and mutual advantage between private landowners and the owners of public lands and wildlife. Now, as for wildlife law, it establishes itself as the state system in direct response to the private commercial exploitation of wildlife, from the wanton slaughter of bison to beaver. But on what basis would state government and state courts base such a system? At statehood, Montana citizens, not serfs, rejected an English system of wildlife law that tied access to wildlife to land ownership. A feudal system. American wildlife law is a direct repudiation of this model, and it responded to problems of commercial exploitation with sovereign ownership of a shared resource. The US Supreme Court does this in 1896 in Geer, and the Montana Supreme Court does this in 1923. Both courts do it again, again, and again. And that is the focus of my paper and my contribution to the symposium, to examine the roots of wildlife law and management in Montana, which is the so-called public trust doctrine. This is an ancient doctrine incorporated into both federal and state jurisprudence. And the doctrine, in short, calls for trustees of wildlife, such as the state legislature, Montana Fish, Wildlife, and Parks, to manage the corpus or assets of the trust, fish and wildlife, for present and future generations of Montanans, its beneficiaries. Now, the doctrine stands apart from and is also embedded into the Montana State Constitution, such as the state's sovereign ownership of water and the right to a clean and healthful environment. It played a foundational role in the stream access cases and was once again invoked by Judge Seeley in the Kids Climate case, the health decision. So just to be clear, the doctrine is not a magic bullet, not an invitation to run roughshod over private property rights, but it ensures that public rights to public resources are part of the equation, something to be balanced with constitutional rights to private property. It calls for accommodation, continuing supervision of public trust resources, and it provides a most important counterweight and assurance that the public interest in wildlife is not surrendered to private monopolization or undue private control of the wildlife trust. The doctrine can also serve as a coalescing and unifying force in wildlife management for the benefit of all species, game and non-game. Now, the doctrine is also said to serve a similar foundation in the so-called North American model of wildlife conservation. It is the guiding legal principle for the Association of Fish and Wildlife Agencies and the Montana Department of Fish, Wildlife, and Parks. The department just 3 years ago, as you can see here, celebrated the doctrine and emphasized that its legal application is the North Star of wildlife law and management in the state. It's so-called legal bedrock. 2 years later, with no media attention whatsoever, whatsoever. The department just sort of casually stated in court that terrestrial wildlife has never been and is currently not covered by the public trust doctrine. When it speaks of the public trust, said the agency, it did so in a sort of rhetorical way, like it's managing for some vaguely stated public interest and not really the public trust doctrine as a legal thing. But that is not so, as I explained in my contribution. And I believe that the agency's recent position is dangerous, alarming, and may have unintended consequences, like casually removing a first-story block in a game of Jenga. You might want to be careful. There is also an administrative lesson to be learned from corner crossing. Muscles and memory atrophy if not used. Agency muscle and memory included. Consider here the position taken by the Forest Service, and until recently, I think, the BLM, when it came to accessing federal lands at the corner, either dodging the issue or going so far to say that accessing federal property is actually a state or county issue. Viewed this way, corner crossing is now an issue because federal land agencies made it one. So where do we go from here? Now, I hate to sound so parochial, but this is the 40th anniversary of this symposium, and dozens of legendary Montanans and conservation icons have shared their stories, their insights, and strategies at past conferences. From writing the best state constitution to Montana's rich history of providing stream access. And I believe the latter offers some guidance in how to proceed with today's debate over access. First off, the storylines are quite similar, as the famous stream access cases on the Dearborn, the Beaverhead, the Bitterroot also involved large, wealthy landowners who wanted to exclude the public from its waters and fisheries. Montana's stream access law is also instructive because the victories were rooted in first principles, the public trust doctrine and the Montana Constitution. And these legal victories provided the leverage to find a number of workable, pragmatic, and durable statutory solutions to stream access in the state. Solutions that protect at once the public interest and also private property rights. So though access to federal lands and access to wildlife share similar roots, their solutions will differ, of course, with corner crossing taking the federal pathway and the wildlife issue a more state-centered one. But there are important connections here. At the state level, it is imperative for the state to once again embrace the public roots of wildlife law, which is the public trust doctrine. A most important counterweight to the forces of monopolization and privatization now before us. The doctrine, along with the state constitution, can once again provide the leverage needed to find a number of workable and durable solutions to balancing public and private. Now, federal public lands are what Charles Wilkinson described, quote, at the outer reaches of the public trust doctrine. But federal courts use the doctrine to reinforce and strengthen federal powers over public lands and the wildlife on it. Federal regulations also state clearly, quote, fish and wildlife on public lands are held in public trust by the federal and state governments for the benefit of present and future generations of Americans. We can also go back to the 1897 decision of Canfield, where the Supreme Court first applies the Unlawful Enclosures Act. In doing so, the court invokes the government's, quote, duties as a trustee to prevent an individual or private corporation to monopolize public lands for private gain. If Congress was not such a dysfunctional mess, one could imagine it using this foundation to update and clarify the Unlawful Enclosures Act, making it easier to enforce, or to ensure that any private use of public lands comes bundled with provisions related to public access. You want a grazing permit, an outfitting permit, and the terms and conditions of this new contract include a simple reminder that public lands and wildlife belong to everyone. Thank you.
Would it be okay if I stayed sitting? All right, I'm all tangled up. Okay, I just need to go one whole spot. Two whole spot. There's my last few minutes. Great. Good morning. Hi, my name is Lauren Van Schilder. I am a member of Coach Pueblo and an assistant professor at UCLA School of Law. I am so grateful to be here. Thank you to my co-panelists, to our moderator. Thank you to the Public Lands Journal. The students have been doing so much work gathering it up. Also, thank you to all of the tribal people here. I see some of you and your jewelry. I am not a public land scholar. Rather, I work in federal Indian law and tribal law, which is itself all law, just as it applies to Indians. But I am excited at the invitation nevertheless and offer some more loose thoughts about how I can contribute, particularly as public lands and access intersect with native access to public lands as well as tribes. In some of my other work, I am looking specifically at international law, which has really broadened my eyes to the ways in which Indigenous people are interacting with their environments all around the world. For better or for worse, there are a lot of commonalities. The whole concept of indigeneity, particularly at the international level, is a relatively new concept. The irony is that the United States, amongst other settler colonialists, helped to craft this concept in part by efforts at forced assimilation, including things like boarding schools that brought a bunch of different Indians together in the same place. They started dating, made cute little pan-Indian babies, and these babies started adopting a pan-Indian identity that leveraged advocacy on a more global scale. Indigenous people have been advocating for international recognition for a long time, including at least as early as the 1920s, in which a chief of the Mohawk Nation went to Geneva requesting recognition in order to advocate for the ways in which the Canadian Indian Act was infringing on their rights. He was rebuffed, though was treated like a celebrity in the city of Geneva, including a reception by the mayor, which is interesting. But that's all to say that Indigenous people have been working at this for a long time. The concept of Indigenous peoples is it is not precise. This imprecision is intended to be encompassing. Some components include the importance of self-identification. It includes a connection to the land in a deep, meaningful, spiritual way. It also includes a historical context that manifests in a relationship to a colonizer and a condition of oppression within the current nation state. International law itself, for those of you that are not familiar, really endorses the notion of a nation state. It recognizes the juridical actor as the nation state and individuals. That's a problem for Indigenous people, because Indigenous people are advocating for not just the rights of individual Indians, but for the right of the collective. So a lot of the advocacy taking place at the international level is a recognition of the collective, something that is sovereign, has rights of self-determination that may exist next to, or at least at some other level to the nation state. Indigenous people have also been specifically advocating on the notion of public lands managed by the nation state in relation to their rights. In 2003, at the Indigenous Peoples Ad Hoc Working Group for the World Parks Congress, a advocate stepped up and stated, first, we were dispossessed in the name of kings and emperors, later in the names of state development, and now in the name of conservation.
That is a stark characterization, but I think an apt one for the ways in which a lot of Indigenous people perceive public lands as really the next iteration of dispossession of tribal lands and the cutting out of their opportunity to participate. Now, there have been some successes internationally, including with the ratification of the United Nations Declaration on the Rights of Indigenous Peoples. This is not a binding instrument, it is just a declaration, but perhaps a statement of international customary law, or at least general principles for how we should understand human rights, specifically as they apply to Indigenous peoples. The UNDRIP is a big fat deal, in part because it recognizes for the first time on the international forum, collective rights, the right to self-determination by Indigenous peoples. There are also specific rights about the importance of land, access, and decision-making in those, and access to those lands. Now, this notion about being dispossessed by public lands, I mentioned that there's commonality around the world. It's bizarre. The Karen in Thailand, Botswana, Nicaragua, Bolivia, Ecuador, Peru, all of these countries have a really similar story of forcibly extracting Indigenous people for the purposes of creating a conservation area. Part of this is considered to be modeling what is often described as either the old paradigm or in fact the Yellowstone model. It is a notion that protected areas should be created and governed by the state. The goal should be strict nature preservation. Effective management requires that there is no human use, including no human habitation or agriculture. Finally, coercive force is legally and morally justified in pursuit of these goals. Essentially, the notion under this old paradigm is that to protect the land, we need to protect the land from people. From an Indigenous perspective, this is kind of weird. Not only have Indigenous people been stewarding the land for generations, millennia, but the notion that Indigenous people should be separated from the land kind of doesn't make any sense. That's our relatives. We're connected in a way that separation just doesn't really logically fit. But it also doesn't make any efficiency sense. 80% of the world's current biodiversity is managed by Indigenous people, despite efforts to remove them and create conservation areas. In every metric across the world, Indigenous steward lands have higher biodiversity and healthier landscapes than lands specifically designed for those purposes. Indigenous people, turns out, are kind of good at it, in part because they've been doing it for millennia and have ingrained a model that prioritizes a healthy landscape. Part of that model is a recognition that a healthy landscape can't just accommodate people, it requires people. Indigenous peoples are a critical component of this metric. Now, here in the United States, we have a sordid history. I think it is not irrelevant to note that the Yellowstone model that premised the creation of the Yellowstone National Park, one of our shining star national parks, was first seen by non-Indians. These non-Indians were the Mariposa Brigade, a military brigade that was specifically mandated to go out and clean out the valley of the Miwok Indians in pursuit to the gold rush. The gold rush, there's no way to overstate the devastation and genocide that wreaked on California Indians. It is directly a direct cause for why California Indians are so small in number and likely so underdeveloped compared to the rest of Indian country. That, I think, is a origin story. It's not the origin story, in part because Indian country is not only a complex story, but it is a story still very much unfolding.
The often characterization is that most land dispossession took place in the past. It was unfortunate that it could have been handled better, but it's something that was happening in the past that we are now actively trying to get beyond. I would argue that's not totally accurate. If by only one metric, the Dawes Act that was enacted in 1883 helped facilitate more land dispossession up and through the 20th century into 1934. I note the Dawes Act in particular because as part of the public lands mantra is this endorsement that collective ownership with a public trust goal is worthwhile. But this is in contradiction to the policies that were being pursued at Native Americans. At contact, and certainly through the endorsement of doctrines like the Discovery Doctrine, was an argument, whether it was fully embraced or at least put on the page, that Indigenous peoples were a lower tier of civilization. We have to back up, right, is a notion that humanity is on a linear progression of tiers of civilization. Thinkers in the 18th century, like Amir Fatal and Hobbes, would argue that Europeans happen to be a reflection of the most progressive form of civilization. Attributes of this civilization include agriculture. They also include private property. These are necessary ingredients in order to form progress, culture, education. Indigenous peoples are on a lower tier. Because they're on a lower tier, we're justified in not recognizing their property rights in fee simple title. We'll recognize them only as possessory Aboriginal title, which is still better than what a lot of other settler colonialists did. Looking at you, Australia. But as part of our discovery of America and a recognition of Aboriginal title, we are going to assert sovereignty over this country that will become the United States and enter into a guardian board relationship with tribes. This is relevant not only because it's paternalistic, but it frames the legal dynamic between Indigenous peoples and the United States. The United States still recognizes sovereignty, but it is always in this guardian board framework, what we now call the trust responsibility. In pursuit of the trust responsibility and in the various mechanisms by which Indigenous people negotiated land swaps with the United States, there were sales, but there were also policies to remove, sometimes forcibly, onto reservations. Today's Indian law is very much steeped in trying to navigate what the purpose of these reservations are, because the purpose impacts the potential property rights that Indigenous peoples now have in their lands and resources. These purposes go right back to this linear progression of civilization. The purpose was to convince Indigenous people of the benefits of private property and agriculture, and we thereby only couch the limited property rights that we'll recognize for Indigenous people in a field that is cut off from other Fifth Amendment type property recognition as being in pursuit of agriculture and this framing of civilization. I note all of this history because I think it's relevant when we then talk about what it means for Indigenous peoples who have been forcibly removed from lands in order to preserve the notion that is ultimately false of a pristine environment that is free from people, a status that these lands have not enjoyed, at least for the last 20,000 years. And to then thereafter construct what it means for Indigenous people to gain access to it. There are treaty rights that I know are a big deal here in Montana. I'm from New Mexico. The Cochiti Pueblo, along with the other 20 Pueblos, don't have treaty rights directly with the United States. There is the Treaty of Guadalupe Hidalgo, which recognizes the transfer of the greater Southwest from Mexico to the United States that requires a recognition of all the property rights that included the Pueblos. We were talking about that at dinner. But there's no direct property rights. Nevertheless, all of the treaty cases really inform what we now understand. For many indigenous people, there were provisions for hunting and fishing. These hunting and fishing rights are often recognized off reservation through a lot of litigation that's often rooted back to the trust relationship. That we are going to use the trust relationship and the guardian ward differing power positions to infer the best understanding feasible for the natives that include a sustained access to hunting and fishing. I want to go back to what it means for indigenous peoples to engage in hunting and fishing and access, like cultural gathering of foods, acorns, and other plants. Part of this is not just sustenance, though it is a massive component. It's not just cultural, though it's a massive component. But it is considered a reciprocal process. The gathering of game, of plants, of participating in cultural ceremonies is not just given to the people, but it is also necessary to give back to the land. And in fact, authors like Robin Kimmerer in her Braiding Sweetgrass book, which if you haven't read, stop what you're doing and go read it. It talks about how beneficial it is when indigenous people engage in cultural gathering and how regenerative it is for these lands. There's been a lot of attention now about the benefits of wildfires, and a lot of indigenous people be like, I told you, particularly in California, where up until 5 minutes ago, the thinking was that any fire is bad. And so we need to do everything that we possibly can to prevent fire. When in fact, some fire is good. In fact, it's not just good, it's necessary, because a recharging fire will minimize the overgrowth of brush and prevent the harmful big fires. Indigenous people have been advocating for this for millennia. In fact, the old Spanish manuals, when they came up the coast of California and saw the Golden Hills for the first time, made notes about the fires that they saw. They also made note about the incredible paradise that they saw, without realizing that those two were not just connected, but what they were seeing was a highly curated and managed land that was not an accident. It wasn't Eden, it was a curated land taken for by the people. Today, access is arduous for a lot of indigenous people. This includes the treaty rights, as I mentioned. There's advocacy from a religious component, arguing the importance of accessing for sacred spaces. The case law here is very disturbing. The primary case, Ling v. Northwest Indian Ceremony Cemetery from 1988, refuses to acknowledge a religious right for the Yurok and group people in regards to the destruction of a particular site on U.S. Forest Service land that was necessary to build a logging road. Congress eventually intervened from recognizing it as wilderness, so still not a sacred site, but protected the land. The Ninth Circuit's Navajo Nation versus the United States Forest Service exacerbated this ruling, again holding that there's no religious protection for Native people. And now we have a case sitting at the Ninth Circuit for Apache Stronghold versus the United States regarding the potential protection or destruction of Oak Flat. Oak Flat is an incredibly important area to the Apache, including San Carlos Apache. It is also the area that was the subject of a 2014 Midnight Rider land swap, in which the federal government gave the land to Resolution Copper for the purposes of opening what will be the largest open pit copper mine in certainly the US, I think the world. It will be a mile wide and will absolutely completely destroy this site, a site where Apache women have their coming of age ceremony. That is at the Ninth Circuit under what has been a losing argument about the right of Indigenous peoples to have their religion protected. I come back to international law because the losing argument for sacred site protection often hinges on the failure for US law to recognize the collective. There's lots of case law recognizing individual Indians and their religious protection, the peyote cases, or the right of prisoners to have access to a sweat lodge. But when it comes to the collective, we stumble a little bit. It's not a coincidence that the United States was one of only 4 nations that voted against the UNDRIP. They later changed their vote in 2010, but in doing so, the United States argued that we now endorse the UNDRIP in part because we're already complying with it. Indigenous people might disagree. Some other effective means for access for Indigenous people have been co-management. We've heard a little bit about that already today. I would note the picture that you're looking at. Can anyone tell me what the picture is? It's Kashakatui. This is Kashakatui, also known as Tent Rocks. It is from Cochiti Pueblo. And I note that it's one of, I don't know if it's the, but it's certainly a original co-management example. It was established as a national monument in 2001, pursuant to a presidential proclamation made by President Clinton. In that presidential proclamation, they didn't just create a national monument, but mandated that the Bureau of Land Management would have to co-manage Kashakatui with Cochiti Pueblo. With this mandate, there has now been 22 years of experience in co-management, including closing Kashakatui during ceremonially sensitive areas, discussing the location of the parking lot, trash pickup, the extent to which certain areas are overloved and in need of protection, and generally helping to build a model of what it means to engage in a way that is respectful of this land, not only because it's public, but because it is culturally sensitive to the Cochiti Pueblo. I think that this part of like normalizing our relations is something that Indigenous people can really help us with. Again, going to Robin Kimmerer, an argument that she makes that I really like is her observation that Indigenous people are currently a minority in the world, and in fact, it is their minority status that defines their indigeneity. But all people are Indigenous somewhere at some point. Part of what it means to be Indigenous is to be connected to the land in a way that is directly relevant to your life ways. Part of, I think, the critique of Indigenous peoples is not just the way in which their rights have been neglected, oppressed, suppressed, but is the failure for the visitors to this land to indigenize themselves to this space. That the capacity of overloving a public land is really just kind words for being disrespectful, for being neglectful, for being unmindful of the obligations we owe to these lands. And so it's really a calling that like we invite you to embrace these lands with the same love and commitment to reciprocity as we do, because it is all of our obligations to take care of this place. I'll close with just noting some ways in which the Supreme Court is sort of positioning federal Indian law right now and where I see that relevant to public lands management. We've had a couple of big treaty rights cases lately, notably the McGirt case, but specifically in regards to public lands, Herrera and Cougar Den, recognizing the right to hunt and fish off reservation. This is a big deal because this court has not always recognized treaty rights, but has recognized the extent to which the guardian federal government can unilaterally abrogate those treaty rights at whim. It's that abrogation that really underscores the issue for Indigenous peoples. Within the United States, given this federal guardian framework, there is no actual
political participation for Indigenous peoples. We're not built into the Constitution. The United States doesn't understand itself as a plurinational nation. Instead, tribes are just kind of out there. And there's a sense that it's like, oh, should we consult with them? I don't know. Do we have a mandate? No. We have a couple of executive orders, but the extent to which some federal agencies have a consultation policy and some don't, we know that those are encouragements, suggestions at best. Australia, I was mentioning them and criticizing them because they recognize terra nullius, or a recognition there are no Indigenous people up until 1990. Recently had a ballot initiative about whether or not they should build in Indigenous people as a recognition in their parliament. They voted it down, which sucks. But I would note that they're entertaining what it means to engage with their Indigenous people in a sovereign to sovereign mechanism that the United States just isn't. There are instances where the United States is far beyond other nation states, most notably the recognition of tribal internal sovereignty and jurisdiction over their tribal lands, asterisk, asterisk, asterisk. But there's no particular recognition for political participation. Tribes don't have representation in Congress. There's no mandate that any particular branch, federal or state, need to engage with tribes. To me, this is part of the problem. And so we're like feeling our way in the dark for how to navigate with tribes. If it feels clunky and awkward and weird, that's because it is. Tribes similarly are trying to advocate for their rights, but we just got recognition like a couple of years ago. And so this all feels very clunky and hurt because we don't have a legal framework to do this. Alan B. Brackeen regarding the constitutionality of the Indian Child Welfare Act doesn't seem super relevant here, except this was a double down that the federal government has plenary power over Indian affairs, including Article 1 powers under the Indian Commerce Clause and the treaty powers, and the trust responsibility. The trust responsibility is kind of like the big thing that we got, and I think we need to really roll with that. Of course, it's troubling because in the same term as Brackeen, we got Arizona versus Navajo Nation regarding the water rights of the Navajo Nation. We recognize federal reserve rights like, okay, Navajo, but the federal government was found to have no positive obligation to quantify what those rights are. That means that under the trust responsibility, there's no actual obligations there. Which I think goes back to, we're at a dead end. How do we work together when we don't have a legal framework for doing so? It's certainly an invitation for building this framework. Engaging with tribes, I think, is only a good thing, but we are definitely building the road as we go. I'll leave it there.
So the first question I'd like to ask our panelists, so we've talked about the private trust doctrine and the public trust doctrine. So how are the two doctrines complementary to each other and how are they in conflict with each other?
There is a debate in Indian law about when a tribe negotiates in a treaty with the federal government, is the tribe reserving rights that they possessed all along and ceding everything else? Or is the federal government giving the tribes land and water rights? Depending on what court case you're reading and what decade, the difference changes. And to me, this is an area where the trust obligation comes in direct conflict with the public trust doctrine, because the question is, are tribal lands being pulled from public land, or is public land being pulled from tribal land? And this gets tricky. I think where we see hope is in places like Kashikatue and other co-management areas where we have land that we recognize as public, that the public has right to access to, but in which we have also recognized Indigenous right to help manage, including on when we need to close public access because it is not being giving to the land. That's like a non-answer.
Professor Stark, I had to, maybe it's from my training, I think I approach the issues in such a just similar way. I'd have to give it more thought, but like when I think of that trust obligation, but like I thought about the access issue from the tribal standpoint too, and I guess my head goes back to the, Winans and those core cases. And maybe I'm mistaken, but I kind of come at it from a different way. And maybe it's just limited capacity in my, the public trust doctrine itself is such a fractured doctrine. It's state common law, 50 different doctrines that have all developed somewhat differently per resource too. So from tidelands and navigability and fish and wildlife. And so in my head, I often think of like a source headwater with different tributaries, but I've never really included the tribal part of that in my sort of analysis. And maybe that's wrong, but and I have 15 minutes, so I really stuck to I took off too much just with the federal public lands and wildlife. So I would not feel comfortable like making some connection there right now.
So when we talk about. You haven't followed? So when we talk about the foundations being all these fragmented policies, is there a need to decolonize both the foundations of public land law and Indian law? How does that play out?
So these are big questions. I was talking with Wes last night, who is he's not self-described, but I'll describe him as a Section 106 expert. Everyone knows what Section 106 is? Part of the National Historic Preservation Act. It is a procedural component for the federal government to, before there are any projects on federal land, to measure environmental impacts and potentially also cultural impacts. Tribes, sovereign governments have the authority under Section 106 to engage in this administrative process. It is purely procedural, and it was not built with tribal concerns as its core motivation. It has evolved into that, and it ends up being one of the sharpest tools in the tribal toolbox for protecting cultural resources on tribal lands. We have a comparable iteration under state law, but I would point to that as like one fruitful example in an otherwise barren wasteland. I think just a lot of public lands, it didn't occur to Congress or to federal agencies that tribes needed to be a component in this for the reasons I stated, right? They're cut out of the legal framework. And so to the effect that like we forget about tribes, right? Is it a coincidence? And so I think building tribes intentionally into this process, including through things like Section 106, but with the cause of action, would be one place to go. And yeah, like federal Indian law needs to be burned to the ground.
With a simultaneous replacement.
Ideally.
Well, I'm raised Irish Catholic, so this is going to sound like a confessional, I think. The public lands, to be candid, like the public lands have defined my professional life and my personal life in a significant way. And I think I differ with Professor Leshy. I see, the history of public lands to be a little darker, especially in American conservation. There's a dark side, and I'm fully aware of that. you know, like when you think about the creation of Yellowstone or even the General Revisions Act, you know, which essentially creates the National Forest System, sandwiched between those two laws is the Dawes Act, where you have within, I think, the same month, President Roosevelt, you know, designated monuments and endorsing the Dawes Act as being, quote, I think this is right, like a mighty pulverizing engine to break apart the tribal landmass. Like, we have to deal with that dark history. But, you know, some of the most moving literature that I've read was Sarah Krakoff, who I believe is at Interior still. She does this wonderful job talking about Bears Ears and the history of the Grand Canyon. And yeah, go through that dark space. But those public lands now provide tribes this space to actually do healing and reconciliation. And so I'm still all in on public lands. And I see cases of land back, land restoration, tribal co-management, stewardship, like a menu of options that I've dedicated a big part of my career doing. And I want to finish my career doing that meaningful work. I'll just say one last comment. It struck me when Monty, my colleague and writing partner, Monty Mills, and I started our co-management, our bridges project. It struck me, I go in, I'm such a public lands nerd, I read the Public Lands Law Review Commission report constantly for some weird reason. And that's the last time we've ever systematically reviewed all of our federal public land statutes. It's crazy.
What year was that?
1970. And you know, the only time it's crazy to read, they start, to whom are the public lands important? The national public, the regional public, the state public, private. There's no mention of tribes. The only mention of federal Indian law is footnote 5. And the commission says, well, this is public lands law. That's federal Indian law. And the two are like these separate things. And to me, that sticks because it explains, like I work with agencies and federal public land agencies so often, they treat their trust and treaty obligations as ancillary, as this sort of reactive check the box exercise. And I think until we merge that somehow, we're gonna have similar problems. So, man, it's a big question, you're right.
I feel weird being the one to say this though. It's like a general idea, right? Like why are the public lands like such a great idea? In part, right, because we look at Europe and specifically England, where there was not an endorsement, right? It is a true like double down private property is the best thing ever. And if it's not private, it's royal, it's nobility. And so like the whole like I was reading a thing about, you know, why is American culture like so into hunting? Like why is hunting such a big deal? And their argument, and like realize I'm in Montana, but their argument was that in England, hunting had been so effectively criminalized because hunting was only for the nobility and for the royalty on the king's land, that it finally coming to America was an opportunity to reject and abandon this privatization. So it's sort of ironic that we see indigenous people and like their collective ownership and like they need to be civilized while also embracing the opportunities for being in like the new world and to have something like the public lands, I think is like, to your point, they are so intimately connected, it's almost difficult to like articulate.
So talking about tribal co-management or tribal co-stewardship agreements, looking at whether it's Tent Rocks or Forward in some of the work, looking at over the last few years, a number of agreements, any provisions that stand out that are really helpful for facilitating true co-management and any provisions that feel hurdles to achieving true co-management?
let's say after these last 5 years, working with Monty, working with Interior, working with so many agencies that I don't see it. This is, the runway is clear to do real shared decision-making and authority, especially with the Secretarial Order 3403 calling it for co-stewardship. And the way, we can sit here and parse co-management, co-stewardship. The agencies, including the BLM, lump co-management under co-stewardship. So there's a wide range of options. And we can talk about subdelegation doctrine and all of that stuff, but man, there is, like I said, the runway is clear. I would still say the biggest impediment is institutional culture within our core federal public land agencies. And I think that is embedded. Yes, it's a financial issue, capacity issue, but I think it's even deeper than that. And in all of our cases that we've investigated, it's just like these weird blockades that happen by mid-career line officers that don't want to do things differently, don't want to share authority. And so I think that's embedded within the senior executive service and how we do performance metrics. We uncovered examples where federal employees in Alaska were being rewarded by their cooperation with the state of Alaska. And you wonder why there's that, they bend over backwards, acquiesce to Alaskan demands, and nothing like that with the 227 Alaska Native tribes. So I think it's institutionalized, and we hope to bust that open soon.
I think that's exactly right, in part because we see the same phenomenon on the consultation side, right? Just like a real hesitation to engage, in part because it's not normalized. We see this in NAGPRA compliance, just, right? It's been 30 years and like just a real hesitation. We see this with compliance with the Indian Child Welfare Act. These are statutory mandates, and still you get resistance, in part because it feels weird to engage with tribes. I point again just to the international framework and looking at this phenomenon of kicking Indigenous people out in order to conserve the land. One of the calls is for the free, prior, and informed consent of Indigenous peoples, which is one framework for tribal decision-making, exactly what you're calling for.
And Professor Stork, I would say too, and I think I've sent some of your scholarship to people I've argued with. So we need more examples of conservation success on the ground. And so one of the things that was so striking in Herrera, right, is like Wyoming, oh my God, it's covered. If we have to possibly share harvest development with tribes, oh my God, we can't possibly do this. The whole North American model is going to crumble. They have managed to figure it out in the Great Lakes states, in the Pacific Northwest. But those examples of that level, we can talk about the bison range, right? We need more examples of that I think are going to win over not only federal agencies, but NGOs and others.
So when we think about land back as either co-stewardship, actually returning land to tribal ownership, or any of the other models, what's the importance of non-tribal access in achieving that goal?
I have like a little tidbit. So I work with especially in California. If you're not aware, California is a public law 280 state, 1953 law that when the federal government was trying to get out of business of Indian affairs, transferred criminal and civil adjudicatory jurisdiction to the state. It didn't do anything to tribal sovereignty, but it had a chilling effect. The consequences that a lot of the tribes are governmentally speaking, quote, like underdeveloped compared, they're also just smaller tribes. And so there's just a lot less capacity to engage when somebody says like, hey, we're gonna like give all this land back. It's like, that's great. Like, we can't take it, in part because like like, you're giving us the land, but like, I didn't see any dollar signs that were gonna come with it in regards to maintenance, which I think is a huge component of land back, that land back should include dollars for land maintenance. But there are other people that are interested in gifting the land back, but are deeply concerned about this public access component. It has fostered the creation of a host of conservancies. There is a sordid history about land conservancies and tribes that is related, but obviously tangential. Tribes have started to open their own conservancies. There are a host of models. Some are intertribal, some are wholly tribal. The tribe we were working with actually started it under tribal law, and so the decision-making is itself tribal. But in gifting the land, it is not just a, here's the land, do whatever you want with it. It's a, here's the land, but we're giving it with conditions that include conservation and access. And that has been a seemingly, I don't want to say like good or gold star or anything, but a good route for some tribes, in part because a lot of the conservation goals align with the tribe. I will say an interesting development here, though, has been the building of a tribal definition of conservancy that is like, quote, indigenized, but is really broader. Conservation, depending on the land conservancy, sometimes means zero development. It might even mean zero people. Going back to like talking before, for tribes, that like, that's ridiculous. People are gonna be accessing midland. Like the whole reason for this is that we want people to access the land. That access can include the public, but it might also include development such as like a cultural building or a cultural site, or even sustainable housing, because engagement with the land is just gonna look a little bit different under the tribal conservancy law. And to me, that's a really exciting potential area of development under tribal law for like law students out there.
Well, this is that confessional again for me, like we have, well, like the talk about land back of all public lands makes me like seriously have anxiety, right? Like just from a, yeah. I mean, I've gotten in trouble in that whole land transfer of federal lands to the states, and like the state legislature, and like, so like I'm all in. Like I fought that as hard as I possibly could, and so we talk about land back as this hashtag. And so what my colleagues and I did, Audrey Glendenning is here and Monty Mills, we dug in and we cataloged every land transfer from public lands to tribal trust status from 1970, the return of Blue Lake to Taos Pueblo, all the way to the Bison Range, 44 statutes. Audrey, you can tell us how many have access, non-tribal access provisions. There are some that don't, like Taos Pueblo is a famous example. I would have voted for every single one of those bills. And so I think I come at this from a public land advocate, scholar perspective, yet it has really forced me to rethink what it means to do conservation too. And it's forced me to rethink my notions of property. Like just because we may transfer tracts of land to tribal trust status doesn't mean it's going to be that notion of private property that I'm trained in, or just like, the absolutist nature of the property clause in CLEPI without limitations. It could be very different. And I think that's something I've learned over the last 10 or 15 years. And this sounds super weird, but I'm training myself to think of what I would want if I was a fish, and or a bison, right? Like you could make. I know that sounds crazy, and I hope there's no media in the room.
It's just the internet.
But honestly, how do you vote against the return of the National Bison Range to the tribes? like you look at the statute, you have stronger conservation protections now in law than you did under the National Wildlife Refuge Improvement Act and the Comprehensive Conservation Plan. So if I was a bison, I would have voted for the tribe, and I kind of starting to come at. It sounds super weird, but I think we have to put it out there.
Yeah, I'm struck like at least like one stick in the bundle of like private property, right, is the right to destroy. And I think conservation is a real repudiation of that like particular stick in the bundle.
Yeah, and it's hard because Monty and I want to write a piece next, so it's like I want to write a public advocate's guide to land back, where I just do this Irish Catholic confessional thing. Like I want all of it, right? I believe in reconciliation, and I want to merge these things. And Monty's going to write the counter piece, like a federal Indian law guide to public lands, and just to engender a more constructive, honest debate that I think we need to have. Yeah.
Any questions from the audience?
Thank you all so much for this awesome panel. I'm enjoying it immensely. I have a question for the Irish Catholic. What do you make of the Pope's repudiation of the doctrine of discovery?
Oh, wow. Well, I'm also Canadian, so I'm very much in favor of it. But, and I don't do federal public lands, but Matthew Fletcher's work has been insightful to me too, that, there's, I think the far left's sort of superficial look at the doctrine is, I need to defer to the experts here, but it just seems problematic too. Like, at least they're in that, at least in the American version of this doctrine comes a recognition of Indian title. And so we need to be careful in how we think about that.
There
too.
are worse versions.
Yeah.
It's the doctrine of discovery was ingrained into U.S. law in the case Johnson v. McIntosh of 1823, making this the 200th anniversary, auspicious on the 40th anniversary of this conference.
Thank you all for a really engaging panel. My question might be kind of meta, but what does public mean? We have federal public lands, we have the public trust doctrine, which effectively is state by state. And I'm thinking of the Wild Earth Guardians case that you mentioned, Professor Nye, and how we're talking about wildlife as part of the public trust. We've recently seen arguments from the state that, well, the legislature passed these laws that Wild Earth Guardians is challenging. So we argued that, well, that those laws are not in line with managing wildlife as part of the public trust. The state is saying, well, the legislature passed those laws and therefore they spoke for the public. And then we have public meetings where thousands and thousands and thousands of people are disagreeing with the implementation of those laws. Those people are from Montana, the rest of the United States, international. So there's just this huge context of what does public mean, and what does it mean for wildlife to be part of the public trust, especially in a state like Montana, where we have these species like wolves and grizzly bears, which are not found in a lot of the rest of the United States and a lot of the rest of the world. So a lot of context there, but I'm just curious what you all think of that, and what does public mean also in the context of Indigenous people and managing, we're talking about co-stewardship and yeah, I'm just really, how do we define this and how should we define it?
What is representative democracy? At least in regards to Indigenous people, I think of the extent to which like forced assimilation was a policy goal with the aim of absorbing individual Indians into the public for the purposes of erasing the tribe. And so I think that was a real political calculation of dilution, right? Like gerrymandering, in order to dilute like that, like block there. Lots of other reasons, including like we're helping by civilizing. I'm also struck by calls for, even within a representative democracy, obligations by the nation state to be attentive to vulnerable groups. That's often characterized by like as women and children, and the extent to which like the, you know, tyranny of the majority, which I think is sort of like what you're asking, but does the public trust incorporate like entities that we currently don't recognize as eligible to vote, including like landscapes and species? Yes, I think it does. It sort of begs like a doctrine outside of like constitutional, outside of the Constitution, which is like beyond our federalism framework. And so there seems to be friction there.
Yeah, and you know, the public trust doctrine it's a real thing. We just don't talk about it's at least applied to wildlife. It's it comes with procedural, Professor Ryan has written about this, it comes with procedural and substantive duties on the part of the trustee. And we can look at that in terms of stream access to wildlife. And I do believe the public trust doctrine calls into question the way that the state makes decisions about wildlife. That includes the composition of the State Wildlife Commission. And I think it calls into question, I'm going to anger just about everyone in this room. I can feel it already. I'm going to try not to make eye contact. It calls into question the composition of the State Wildlife Commission that's not representative. It calls into question how we do non-game management at the state level. It calls into question this increase of negotiated settlements, closed door settlements that are going on with Montana Fish, Wildlife and Parks. And so I think the public trust doctrine is significant that way. And it's time to be enforced. But this is when I'll try not to make eye contact. It is not a silver bullet either. And I've had people for years trying to get me to write something about the public trust doctrine applied to wolves and grizzly bears, and I refuse to do so. And it's because while I find the state's wolf management abhorrent and sketchy for multiple reasons, and grizzly bear management too, I took a conservative approach in applying the public trust doctrine because, like it or not, those traditional public trust doctrine cases that go to the early 19th century, like Mundy in 1821, they were about access to oysters. They were access to wildlife. And so when I saw that I couldn't stay quiet once I saw the United Property Owners of Montana lawsuit, because in my mind, I followed that case and it hit every single fundamental check for a violation of the public trust doctrine, which is the private tying wildlife to private lands. I mean, we rejected that system. And so I'm just like airing it all out, but that's how I see it.
Thank you.
Hi, I love that the two of you are on the same panel because I see so much overlap between the work that you both are doing. And both of you have optimisms for tribes and public lands, which is, I think, really awesome and encouraging for so many of us in this room who are stepping into the field of public land, resource policy and law. Now I'm working on this third iteration of bridges, has been looking at resource management plans, Kashmir 2A, 10 Rocks RMP being one of them. And Lauren, I am curious from the perspective of you being a Pueblo G member, whether there are key takeaways from that co-management agreement, and the cooperative agreements to be alongside with the Pueblo that are like critical for other co-management agreements, for tribes. You can see those, like, but yeah, all there.
Well, I can't speak on behalf of the tribe, and I'm not involved in the negotiations about these cooperative agreements, so it's like seemingly an outsider perspective. But my impression is that on the one hand, this is so superior to the tribe just being cut out. There are significant concerns all around New Mexico about the overstomping of a lot of cultural sites. And so the capacity for the tribe to be engaged in how Kashakatue is accessed is great. On the flip side, I will say that it's like, oh, the tribe must love this. They don't. This is the best of a bad situation, I think, from the tribe's perspective, that the extent to which they are not, this is where I think, like, what do we mean by co-management? I don't think we ever mean equal decision-making authority. We just don't. In part because we just haven't naturalized the idea that tribes deserve to be a equal partner. Instead, it is BLM land, and the tribe is frequently invited as like, you should be grateful for being invited here, and you get what you get. And so anytime the tribe insists on anything, it's considered being like they're putting someone out. I'm being over dramatic about the characterization, but I think the sentiment is that it's rough, and every crumb has to be fought for. And so, you know, the flip side compared to other sites, I think like this is still really beneficial. Having the tribe built into the creation of the national monument is ideal compared to like regional management plans where co-management is like tacked on later, in part because they may in theory have equal authority, but the reality is, as we're trying to normalize this, having the agency in a position where they feel like they have no choice is helpful in helping to structure what the relationship is going to be. It's also helpful that the tribe is right there. And so they have eyes on the ground about like what's going on. It's tribal employees that are welcoming visitors and that are picking up trash and directing traffic. And so that helps in helping to navigate. And so there's buy-in about when they say like, we need this happened. That helps. But I think a lot of it comes down to like the squishy, what are the expectations even before we come to the table?
We are at time, so I'd like to thank our panel for.
Okay, so my name is Jennifer. I am co-EIC with Sawyer, and I am very pleased to be announcing our lunchtime speaker, Devlin Geddes. Growing up in Oregon, Devlin first came to Montana to attend Montana State University, where he earned degrees in justice studies and physics and played football for the Bobcats. He then continued his schooling at the University of Oregon Law. Following graduation, Devlin started his legal career in Seattle before returning to Bozeman to join the firm at which he's currently a partner, Getz, Geddes, and Gardner. Since returning to Bozeman, Devlin's practice has ranged greatly, from antitrust to class action to security violations, and everything in between. On top of that already expansive list of practice areas, and while we're so excited to hear him talk today, Devlin has led the charge in Montana to preserve access to public lands, rivers, and lakes. Please join me in welcoming Devlin Geddes.
Thank you, Jennifer. And thank you to the Public Lands Resource Law Review for inviting me to speak today. Can everyone hear me okay? A little tall for the microphone. Before I begin, I want to make sure that everyone understands that I'm speaking my own experiences and my own opinions. And you may understand why I say that a little bit later on. Also, my wife told me that my remarks today seem more like a closing argument than a speech educating people. This is, in my mind, intended to be a little bit of a rah-rah moment, so bear with me. So, as Jennifer mentioned, I grew up in Oregon. And I grew up in a little town called Junction City. It's on Highway 99 between Eugene and Corvallis. When I was a kid, my town was a small farming and logging town. And it's one of those places where you can ride your bike around all day as kids in the summertime while your parents are working, and the community just sort of took care of each other. My parents were outdoors people. I grew up the son of a truck driver. They hunted, fished, camped, and so I did those things with them. When I was about 10, my buddy and I started riding our Huffy BMXs with tackle boxes on the handlebars and rods to this bridge on the Long Tom River just outside my town. I Google mapped it the other day and realized it was a 5-mile bike ride on our little Huffies. We'd go out there and we'd park our bikes right here beside the guardrail and hike down through the brush down to the river edge. We could occasionally catch crappie or bluegill, sometimes some catfish, but we mostly caught poison oak because that's mostly what that is there. Anyhow, that's when I started fly fishing. I didn't have fly rods, so I'd tie a bobber to my line and put a little fly out there. My buddy would put a bobber on and a worm, and he'd catch a lot of fish, and I never would catch any fish. Probably because I bought my flies from the gas station in town. Anyhow, I was committed to being a fly fisherman. So I decided that what I would do is take a little piece of worm and tie it to my fly. And lo and behold, I was a successful dry fly fisherman back then. Little did I know that 20 years later, I'd be litigating public access at county road bridges, just like this one. Before I talk about public access, I want to talk about this man. That's Tony Shonen. When I was skirting through the Poison Oak to access the Long Tom River in Oregon to go fishing, Tony Shonen was pioneering stream access in Montana. Tony was born the 9th of 10 children in 1930 during the Great Depression. At the age of 6 months, him and 6 of his siblings were sent to the Twin Bridges Orphanage on the Ruby River because his parents couldn't afford to keep his brothers and sisters. He lived on the banks of the Ruby River for 13 years until he was hired by Jack Seidensticker, a local rancher along the Big Hole River, as a ranch hand. While at the ranch, he spent countless days hunting, fishing, trapping along the Big Hole and the Ruby Rivers, and he fell in love with Montana's wild places. Tony became one of Montana's first licensed fishing guides, a profession he pursued every summer while he was a teacher and a principal during the school year. He spent a 4-decade career as a fly fishing guide in Montana. He launched his guide service in 1960. He laid down the oars in 2012 when he was 81 years old. When Tony passed in 2019, Montana lost a public access pioneer. As Dan Crockett noted after Tony's passing, he was above all else a bare-fisted brawler for the wild country with a bone-deep conviction that blue-collar people should be able to hunt and fish in Montana. In 2020, Governor Bullock renamed the Notch Bottom Fishing Access Site on the on the Big Hole River to the Tony Shonen Access Site. Anyhow, back in the late 1970s, Tony was fed up with a hostile landowner who was installing barbed wire fences across the Dearborn River right at the water line, preventing people from floating down the river. It not only made floating difficult, but during high water, it could be lethal. Tony teamed up with fellow sportsmen Tom Bugney and Jerry Manley in 1979 to form what was known as the Montana Coalition for Stream Access. When attempts at diplomacy with the private landowner failed, the three scraped together a little bit of money and hired Jim Getz, who Tony called the best lawyer they could find. Jim recalls the story a little bit differently, saying his primary qualification was that he was free. Jim was born in Miles City and raised in Ennis. He graduated from Montana State University in 1965 and Yale Law School in 1968, and he was admitted to the Montana Bar in 1969. His first case was Getz v. Harrison, a case in which he, after failing the Montana bar exam, challenged the diploma privilege for U of M law students. Shortly thereafter, as I'm sure some of you are aware, the diploma privilege was abolished by order of the Montana Supreme Court. I have a note here waiting for booze, but they can. It's the darn Bobcats coming over here and doing this stuff. Once hired, Jim prepared an extensive memorandum regarding enlarging public access to streams in Montana through a test lawsuit. Jim's memo established the legal framework upon which the coalition would seek to establish an expanded legal right for Montanans to use Montana's rivers and streams for recreational purposes. If you are interested, Jim's memo, which was actually typed out on a typewriter, and my law firm's entire set of files regarding our stream access cases over the last few decades are available at Montana State University in the special collection on trout and angling history. Presently, the library states that the file has 13 linear feet of space on the shelves, so it is extensive. Jim researched the notion of navigability for title. We heard a little bit about that during the last presentation. The original 13 states were deemed as sovereigns to own the stream beds of the navigable tidal areas and streams in the United States. The states subsequently admitted to the Union under the Constitution were to be admitted on equal footing under the equal footing doctrine. Thus, the lands under the navigable rivers in territories yet to be granted the statehood were held by the federal government until such time as the state was admitted and granted title to those lands. Jim was convinced at that time that this would be the only way to secure access for recreational purposes on Montana's rivers and streams. Jim investigated what is known as the navigability or navigable in fact rule. It states that any rivers that are navigable in fact are regarded as public rivers for highway of commerce. In his research, he focused on the more liberal test, which was known as the sawlog test, essentially holding that if a stream is capable of having logs floated down it, it is commercially navigable. Then, on the Montana Constitution, Jim analyzed how the coalition could expand the commercial test under federal law, the sawlog test, into what Jim referred to as the recreational use test. With the legal framework set, all the coalition needed was a defendant. And Jim had an idea on that. He recommended that the coalition select the right defendant with the right criteria. After much discussion, the coalition found two such defendants who fit the bill. The first was Michael Curran, a pipeline developer who owned numerous sections of the Dearborn River in Lewis and Clark and Cascade counties. The Dearborn flows out of the Lincoln Scapegoat Wilderness easterly into the Missouri River. And I have this map up here. I'm going to be talking about these three different rivers, but I'm not going to go back to this slide. Curran was both rich enough and irascible enough to be a proper defendant in this case. The second defendant was Lowell Hildreth. He owned 1.5 miles of river stretch along on the Beaverhead just below Clark's Canyon Dam. The Beaverhead River is located in southwest Montana, flows in a northeasterly direction to where it reaches the Jefferson River and then eventually also flows into the Missouri River. Although not as wealthy as Mr. Curran, Hildreth proved to be the right type of defendant. Indeed, once the coalition filed the Beaverhead River lawsuit, Mr. Hildreth threatened that he was going to put chains across the river on his property to prevent people from floating. Thus, the coalition was required to obtain a temporary restraining order just before the opening day of fishing season in 1981. The selection of both the Dearborn and the Beaverhead rivers had a number of advantages. The most important of which is that the Beaverhead had a history of commercial use through the floating of railroad ties down the river, whereas the Beaverhead did not. So we had 2 test cases to present to the court. In a funny turn of events, shortly after filing against Curran, the coalition was slapped with a counterclaim alleging, among other things, trespass by coalition members on Curran's property. It was laughable because the coalition could not even afford Jim's legal bills, let alone a judgment against it. Nonetheless, when the lawsuit was filed, Jim immediately notified the clients that they had been sued. And there was good news and bad news. They had been sued for $10 million, which was the bad news. Jim told him that he thought he could settle it for less than that. During his deposition, Mr. Curran was intent on pressing his counterclaims. He claimed that it took 2 days to float from Highway 287, which, if I can do this, over there, to the Missouri River down here. Jim knew better because he had floated it shortly before the deposition in just 1 day. Nonetheless, Jim focused on the 2-day claim because Mr. Curran claimed that members of the public must be camping on his property while they're floating. And they were littering and cutting fences, et cetera, et cetera. Jim asked Mr. Curran if he had ever floated his property from either here or here to the Missouri River. And Mr. Curran said, yes, he had. Having obtained that concession, he then diverted Mr. Curran's attention to all the alleged grievances that he had regarding the river. Later during the deposition, Jim returned to what he was really interested in. Although Curran owned many sections along the Dearborn River, he didn't own them all. And he conceded, I'm going to go back, that he didn't know who these people were that he floated through on his on the river. Obviously, when he floated the Dearborn down to the Missouri, he went through other people's properties. And the testimony here, which you can't really see, didn't know who they were, and he in fact did it, put to rest his claim that when members of the public were floating through his property, they were trespassing, when he was claiming that when he went through other people's property, he was not trespassing. Ultimately, in 1984, back when I was still fly fishing under the bridge in Oregon, the Montana Supreme Court, relying on the public trust doctrine, adopted Jim's notion that waters that may be used for recreational purposes could not be interfered with by a private party. The Montana Supreme Court followed up a couple months later in the Beaverhead River case and confirmed its earlier decision and adopted the notion that if a member of the, or a private landowner were to block the river, that members of the public could go on to private property to portage around such blockage. With the writing on the wall, the stakeholders met the next year and were forced to compromise their positions during a legislative session. And ultimately, stream access was codified into Montana law in 1985. While there have been many challenges over the years to Montana stream access law, it has survived and it is alive and well today. Jim asked me to bring up the 2012 US Supreme Court decision and the PPL Montana case, which I'm sure a number of you have read about in the news lately. It's important, although stream access was not an issue in that case, the US Supreme Court confirmed that the public trust doctrine remains a matter of state law and that the states get to determine the scope of the public trust over waters within their borders. Stream access is alive and well. It has been decided by the Montana Supreme Court, and the US Supreme Court has affirmed the basis for the decision. After the coalition paved the way for Montana stream access law, many of its visionaries decided they needed a dedicated public access group in Montana. After its 9 original founding members each put $25 on the table in 1985, they founded what is known today as Public Lands Water Access Association, or PLWA. I note on the sponsor board that is a sponsor of this event. Still today, PLWA is a not-for-profit membership organization dedicated to restoring, maintaining, and perpetuating public access to Montana's lands and rivers and streams. If any of you use any portion of the 170,000 miles of rivers and streams in Montana, or over the 30 million acres of public land in Montana, which comprises over 1/3 of our state, I encourage you to join. The dues are still $25 a year. The Ruby River litigation. That's going to talk about you next. This is how I got involved in this area of law. Some people refer to it as the Ruby River litigation or the bridge access litigation. Jim Getz refers to it as the Bridges of Madison County case. The last time I presented at this conference, this case was ongoing, and I was speaking about this case. Anyhow, in 2003, about a year after I passed the Montana bar exam, Tony Shonin and other PLWA members came to me because some landowners on the Ruby River decided to prevent public access by attaching electrified fences to the bridge guardrails, preventing the public from using the right-of-way to get into the river. They did this under the guise of keeping their cattle contained to their private property. Of course, most of these people had recreational properties and no cattle to be seen, but that was the premise for their position. They also put no trespassing signs into the right-of-ways, which I'm sure the cows could read. Being the young lawyer that I was and having spent time fishing in these types of places as a kid, my first thought was, of course we can use the public right-of-way to access the rivers. And my second thought was we needed to solicit the help of the county. County certainly can't tolerate allowing this type of thing to happen, especially when it's hard to see there's an electric fence line right down on the surface of the water. What's the point of that, other than to prevent people from floating the river? I was naive. In September of 2003, PLWA petitioned the Madison County Commissioners seeking to have it remove the fences and no trespassing signs within the bridge right-of-ways at the Sailor Lane, Lewis Lane, and Duncan District roads where they crossed the Ruby River. As luck would have it, This ended up being a great test case because Duncan District Road was a petitioned county road, Lewis Lane was a dedicated county road, and Sailor Lane was a prescriptive county road, or a county road created by public prescriptive easement. Relying on what I refer to as Montana's encroachment statute, PLWA argued to the commissioners that the fences constituted an unlawful encroachment, and therefore the county must remove them. However, rather than removing the fences, Madison County took a different turn. It adopted a resolution creating a process whereby the private landowners could get permission to put those fences up and block the public access. In other words, in addition to refusing to enforce the statute, which by the way says must, they essentially authorize the private landowners to put up the fences that impeded public access. PLWA filed a mandamus lawsuit, the first one that they have filed, and they've since filed many more, seeking to force Madison County to follow the law. We figured that the must mean must. But another irascible landowner had different thoughts. James Cox Kennedy intervened to challenge not only the public's right to use the right-of-way to access the river, but also claiming that Montana stream access law was itself an unconstitutional taking of his property. The result was a decade worth of litigation against out-of-state lawyers with an unlimited litigation budget on the other side. Since I talked about this case the last time I was here, I'm going to skip to the good part. We won. And just like with the stream access cases, the Montana legislature passed a bill codifying the public's right to access Montana's rivers and streams from a public bridge, its right-of-way, and its abutment, and a county roadway. I'm going to mention an incident that we have in Gallatin County presently that this Part B will address. So once again, everyday Montanans benefited from PLWA and Tony Shonin's pursuit of public access. This sign now sits on the Ruby River right-of-way. Not a no trespassing sign, but a yes trespass sign, essentially. And then further, this is a Ruby River access that used to be electrified fencing. You can see now that there's a pass-through and there's actually a roller so people can put rubber boats over the bridge, or excuse me, the fence that abuts the bridge. It's too bad that it took a decade's worth of litigation for common sense to prevail, but it did. Now, before I move on from the Ruby River case, I want to point out a gold nugget in there that a lot of people overlook. As I mentioned, Lewis Lane and Duncan District Road were petitioned and dedicated county roads, but Sailor Lane was a county road created by a public prescriptive easement. One of the arguments being made in that case, as is consistent with private prescriptive easement law, that you can only get an easement to the extent that of your use during the 5-year statutory period. The question presented to the court was whether a public prescriptive easement's use could expand beyond the historical use once it's established. The Montana Supreme Court said yes. Once a public prescriptive highway is established, it may be used for all lawful public purposes moving forward. Now, I was asked to speak about the future of public access. So what is the future of public access in Montana? Well, as they say, history tends to repeat itself. In 1990, Grace Lichtenstein from the LA Times came to Montana and wrote an article about the access disputes in Montana. Earlier this year, Outdoor Life did the same. 33 years of time had passed and access disputes still happen. Despite PLWA's past successes, despite stream access law, despite the bridge access law and bill, Ms. Hill is correct that blocking public access is a tale as old as the West. Next, I'm going to talk to you about the Stolen Bridge case. On the screen, you're going to see an intersection of a 15-year-long dispute that we refer to as the Stolen Bridge case in Teton County. All of this land is owned by a gentleman named Roger Jones. This road here is referred to as the Pishkin-Bodle Road, named after the former landowner of the land. And this road here is the Sun River Slope Canal Road. If you go about 4 miles north of here, you hit Pishkin Reservoir in Teton County. My former partner, Ben Alke, and I represented PLWA against Mr. Jones. And the result of the litigation were 2 judgments, 3 Montana Supreme Court opinions, with public lands access being successful at each and every step. The first judgment, addressing the status of the Boulder Road, was entered in 2003. Following a 1-week trial, and in sum, the court held the public acquired the right to use the Boulder Road by prescriptive easement sometime prior to 1959. The Montana Supreme Court affirmed, and note what is said about the bridge, that the public could use the bridge. Shortly after the Boulder Road decision came down from the Montana Supreme Court, Mr. Jones put a gate up on the Sun River Slope Canal Road, requiring the filing of a second lawsuit, seeking a declaratory judgment that the public could use the Sun River Slope Canal to go northbound to Pishkin Reservoir. After another 1-week trial, the court held that the public could use the Sun River Slope Canal Road, and followed up and reiterated that the public could use the Bodle Bridge, because although Mr. Jones had lost on the Bodle Bridge in the prior case, he raised the issue again. At that point, PLWA had successfully secured a continuous prescriptive right-of-way to traverse Mr. Jones's property along the Boulder Road, over the Bodle Bridge, take a right, turn northbound, and go to Pishkin Reservoir. So what happened next? As soon as the Montana Supreme Court affirmed, the bridge dropped. Note the date, or you can't probably see it. October 2011, the Supreme Court affirmed 1 month prior. Mr. Jones graciously notified the public that the bridge was out and told them that there was no access to Pishkin through private land. Thankfully, during discovery, he took photographs of himself, hiring a company to remove the public bridge and move it elsewhere onto his property. As you can imagine, the jury trial was rather fun. This is the first time I had heard of bringing this claim, but there is a claim in Montana for tortiously interfering with a public easement. And we brought that as claim number 1, and the jury responded, yes. We asked if he was liable for public nuisance. Jury responded, yes. The jury awarded public lands access. Keep in mind, this is a nonprofit public organization. $375,000 to rebuild the bridge, and awarded public lands access $25,000 for the damage caused to its members for the period of time that they could not use the bridge. And lastly, they found that Mr. Jones acted with malice, and he was found liable for punitive damages. So it was a resounding win. But here's my question, was it really? This lawsuit started in 2000. Mr. Jones started blocking the Boulder Road in 2000. And we didn't have a final verdict on everything until 2014. And the Montana Supreme Court didn't affirm this decision until 2015. By stealing the bridge and being irascible, Mr. Jones bought himself 15 years of private exclusive access over the canal. He did end up paying for a nice new bridge. And he paid PLWA's legal fees. But was it worth it for him? The money didn't matter to him. What mattered to him is he didn't want the public to drive across the public road located on his property. These access victories are long, they're hard fought, and they're incredibly expensive. And they're especially so when the other side has unlimited resources. A similar issue is happening right south of here in Ravalli County. This is a sign on the Hughes Creek Road south of here. Despite two Montana Supreme Court decisions holding that the Hughes Creek Road is a county road, petitioned county road, Kyle Nelson and my firm ended up having to file a lawsuit against Ravalli County alleging a mandamus claim under the encroachment statute that we looked at earlier, because the county would not force these private landowners to remove that sign and the gate across the road. After the lawsuit was filed, the county did finally send the sheriff out and the gate was removed. When Public Lands Access asked for its fees, the court said no and dismissed the case as moot. Similar problem today in Bozeman on the Gallatin River. I'm standing on it's called River Road. This is the road that goes from Four Corners out to Norris, and then there's a turn that goes southbound along the Gallatin River. The county road right away goes out here, but the private landowner is putting fences up within the right of way because they claim that people are parking on the county road and doing untoward things. This issue may be the subject of some future conference. I'm not going to go into it because it's ongoing, but I want to point out that despite the victories, there are always going to be people who put these signs up and put these fences up, and the money that they have is limitless. So how do we ensure the future of public access when we're dealing with signs and fences like this? I have three short thoughts. They're my thoughts. And I'm going to leave it at that. First up, public access to Montana's public lands and streams, in my opinion, it's the fabric of this state. Consequently, it's my opinion that the litmus test for any person who runs for public office in the state must be that they support public access. And I don't mean the lip service that most of our politicians give to the issue. I mean, they need to have dedicated service on the subject. They need to approach stakeholders when these disputes arise, because these disputes arise on an individualized basis. And when an organization like Public Lands Access has to come in and fight this one issue, it depletes the money that it has to do other great things like educating the public about stream access, trying to keep people using the right-of-ways correctly, staying below the high water marks, not leaving trash, those types of things. We need leaders who are going to come in and say, this is not okay. They certainly should not be opposing public access to World War II veterans memorials. Our elected officials should stand for public access, not against it. Next, we need to figure out how to change the captions in our cases to get the counties from the wrong side of the V. This is the Jones case up in Teton County with the stolen bridge. Defendant, or excuse me, this is wrong one. This is the Ruby River case. Madison County, #1 defendant. Here's the Jones case. Teton County, #1 defendant. Here is the Hughes Creek case. Ravalli County is the defendant. Volunteer nonprofit public access organizations like PLWA, Backcountry Hunters and Anglers, etc., should not constantly be having to bear the burden of protecting these accesses. With their limited resources, they can't afford to do that. The state of Montana and the counties, by extension, should be seeking to protect public access, not oppose public access. Now, I recognize that our counties, their budgets are limited, especially the smaller counties. I mean, Madison County at the time when we filed the Ruby River litigation had a part-time county attorney. The counties don't want to get involved because they recognize the amount of money on the other side of the V. And so they sit idly, let themselves get sued, and take a hands-off position. As food for thought, what if the state of Montana, through the Department of Justice and the Attorney General's office, gave counties the resources and the support they need to protect public access? We have a process in place like that for criminal prosecutions. On criminal prosecutions that are difficult, the county can't do it on their own. They can reach out to the Department of Justice to get that help. Why can't there be a same process for Hughes Creek? Why does public lands access keep having to sue the counties to get them to do what they're supposed to do? Next, what about the cases where the counties decide, for whatever reason they might, like in Madison County, that they want to allow the public to be blocked out from these places? What if the counties decide to take a position contrary to public access? Food for thought. What if there was some entity at the governor's office, the attorney general's office, where members of the public, rather than just having to haul off and file a lawsuit, could go to the AG and say, will you please do something about this? Will you please instruct the county to step in and protect public access? Now, I'm not suggesting that that means every time someone complains, the AG's office is going to step in. They're going to have to weigh the costs and balance the evidence, but it would pull the burden off of these nonprofit organizations and their limited resources. And these organizations that are litigating precious issues to all Montanans. We certainly don't want one of these cases to fall through the cracks simply because PLWA can't afford it. Finally, the future of public access is sitting in this room. Organizations like PLWA, Backcountry Hunters and Anglers, another sponsor of the event, Montana Trail Unlimited, they need volunteers. They need volunteer attorneys who are willing to work on a pro bono basis, a reduced rate basis. They need the next Jim Getz who says, that's sounds like a good idea, I'll step in and I'll do that and I'll do it for free because it's the right thing to do. Along these lines, I know that Public Lands Access has expressed an interest in wanting to work with the law school here to create, I don't know the word, a clinic, some place where law students, if interested, could come and research issues, investigate issues on behalf of Public Lands Access and other nonprofit organizations. Issues like the blocked West Gallatin River that we looked at with the fence. Issues like access to the East Crazy Mountains, an issue I haven't raised here. Issues like corner crossings, the next Mount Everest of public access in Montana. In closing, I want to refer back to the LA Times article written by Grace Lichtenstein. And I'm gonna do a teeny bit of reading here, so apologize for that. When she visited Montana in 1990 to write that article, she met with then PLWA Executive Director Gene Hawks and former PLWA President Ron Stevens, and they took her out on a drive. It was, I believe, in the Madison Valley. And here's what she wrote in her article. It was a warm summer, and Ron and Gene were about to show me how one landowner tried to block the public's entrance to a chunk of Montana that they believed everyone should be able to enjoy. Along a trail between a rocky ridge and a granite-faced mountain, we paused to take in the view. See this, Hawks said, sweeping his arms in the landscape. This is your ranch. All of Montanans are ranchers, Stevens chimed in. The ranch is the Big Sky Ranch. It includes 8.1 million acres of BLM land, 10.2 million acres of national forest, 5.2 million acres of state school trust lands. Our brand is the Flying R, freedom to recreate. With that, I thank you for your time. Again, thank you to the Law Review for inviting me to speak. And I am willing to answer a few questions with one caveat. I won't talk about corner crossings. And I'm not going to talk about any active cases that we are either investigating or currently litigating. There may not be any questions. Look at that. It's the wedge tires.
Thank you. Can you comment on the Forest Service basically walking away from refusing to defend prescriptive access, which is a public asset that they are basically handing over to some private landowner to prevent the use of some access to public land by prescription?
I can. So my comment is they shouldn't. And that unfortunately, it's another example. I mentioned counties in my presentation, but it's another example where if members of the public want to do something about it, they're going to have to get behind these nonprofit organizations and they're going to have to step in. The issue with the federal property and prescriptive easements over federal land is there is a serious standing question about whether members of the public or a public organization like PLWA can bring that claim. So my concern would be that us members of the public are foreclosed. So my comment is we need to elect the right people who put the correct people into these administrative agencies to do the right thing.
In the federal agencies, you mean?
Yes.
So you can't do mandamus for a federal prescriptive easement. You just have no tools in the toolbox for those cases.
You cannot. Federal Quiet Title Act also, I mean, there's just so many restrictions placed at the federal level. In fact, we've had to, good example, Sun River Slope Canal case. That was the Teton County case. There are chunks of that Sun River Slope Canal Road that goes through land owned by the Bureau of Rec. We could not sue to secure the public access through the Bureau of Rec lands. We had to rely upon a disclaimer by the Bureau of Rec simply saying, we don't take a contrary position, but we reserve the right to block these roads wherever we want to, because we did not have standing to bring that claim against the Bureau of Rec to establish the prescriptive easement. So as of right now, that access over the Stolen Bridge that I mentioned is entirely dependent upon the Bureau of Reclamation's grace to allow the public to go through the public portions there.
I was feeling frustrated by the county commissioners' failure to do what they're supposed to do in enforcing access. I'm wondering if you've considered or tried moving for involuntary status for the counties, if they could, the commissioners, if they could be joined as involuntary plaintiffs. We did that in the Mitchell Slough case, and I will also say the administration changed at that stage, so we ended up getting very enthusiastic Fish, Wildlife, and Parks involved. But
right in the Madison County case, Ted Coughlin, Frank Nelson, and David Schultz, though they were the commissioners, we brought them into that case as defendants. Is that the question you're asking? Or
no, involuntary plaintiffs.
Not given that thought.
They were successful, but again, it was Judy Mertz and then it wasn't, so maybe that was why.
Right. No, I haven't given that any thought. Ooh, your questions are hard.
This one's less rambly than the last one. So one of your ideas was about having a position in the Montana DOJ that could hear from the public, do investigations, and then potentially talk to the county commissions to get them to enforce or to help support them to enforce. How would you create such a position? Is there already a framework for that?
That's a good question. This is not a stump speech, so I'll be careful, but I've talked to Ben Alke, who's running for the Attorney General, about that issue. In his mind, it would be as simple as him appointing somebody to just do that and let the counties know that his office would be willing to listen, investigate, and help on these types of cases in the future. I don't know about the funding mechanisms for the Department of Justice and whether that would be permissible or not. That's just not an area that I know about. I mostly throw the comments out because the food for thought that I talked about, I've been saying this for 20 years and nobody listens. And so I got an opportunity to have some captive audience. Thank you very much. Appreciate it.
Hi, everybody. Thank you for coming back after lunch and welcome to the climate panel. During this panel, we will explore how climate change is going to shape the management of public and tribal lands. We are very excited to learn from our amazing panel today. Unfortunately, Tom and Kathy are stuck in Bozeman and will be joining us on Zoom because of the weather, but we do have Starlin here in person today. And we have our great mediator, Professor Zelmer, here as well. And if you have not had the opportunity yet to look at all of the speaker bios online, you should definitely check those out. And then again, just please help me in welcoming our amazing panelists on Zoom.
So this is, as you can see, the Everything Everywhere Addressing Climate Public Lands Management panel. I'm going to just set the stage really quickly, 5 minutes hopefully, in giving you some of the foundational statutes. This is going to seem very, very dry, but since we're talking about federal public lands, I know you all know something about federal public lands and know probably quite a lot about at least one of the 4 primary federal public lands managers, the Park Service, the Fish and Wildlife Service, both of whom have dominant use missions that may play a role in how they address climate change, climate mitigation, climate adaptation on the lands that they manage. But I'm also going to mention another couple of agencies, the multiple use agencies. You heard from Native Culver this morning. You heard about all of them from John Leshy last night, if you were able to catch his keynote talk. But the multiple use sustained yield agencies have a completely different kind of mandate. that certainly informs how they address climate change, climate adaptation, climate mitigation, and resilience overall. So just for frameworking, the National Park Service Organic Act, you're going to be hearing from Tim Olive in a little bit about how the Park Service is addressing climate change within the units of the National Park System. Here's the language. The purpose is to conserve the scenery, natural and historic objects, and wildlife in the system units, but also to provide for enjoyment of those things in a manner and by such means as to leave them unimpaired for future generations. We heard a lot about the public trust doctrine today, and perhaps the idea of leaving these lands unimpaired for the enjoyment of future generations. Think about that in the context of climate. Perhaps that smacks of some kind of a trust responsibility. We'll be hearing more about that. No, we don't have anyone speaking directly to National Forest Management, or at least not a land manager speaking to National Forest Management, but just to give you a flavor of the organic acts of the two multiple use agencies. The Forest Service has a very different kind of mission, but from the very beginning, 1897, to secure favorable conditions of water flows, not just timber, guys, not just timber, to secure favorable conditions of water flows. This was truly foundational in the formation, creation, and expansion of the National Forest System in the United States, and also to furnish a continuous supply of timber. Building on that in 1960, and I won't read through all of this, but the Multiple Use Sustained Yield Act was passed, the first explicit direction to one of the federal land management agencies to manage its lands for multiple uses and, at least with respect to renewable resources, sustained yields over time. So multiple uses in the BLM lands look a little different in terms of the description of multiple uses, but the concept is quite similar. Recreation, range, timber, watershed, yes, watershed is in there, wildlife and fish purposes, in addition to the original 1897 acts, multiple use and sustained yield. And then 1976 is when both the National Forest Management Act, the modern Organic Act that builds upon the predecessors for the Forest Service, and the Federal Lands Policy and Management Act, or FLETMA, for the Bureau of Land Management, both came to line in 1976, within just a very short period of time of each other. So Congress was very much thinking about the Committee on Public Lands report that Professor Nye mentioned a little bit earlier, and thinking about, well, okay, multiple use sustained yield has not really given the appropriate or the clearest of parameters for the management agencies and telling them how they're supposed to balance multiple uses and maintain sustained yields over time, focusing again on the Forest Service and the Bureau of Land Management. So in NEFMA, you see a very marked focus on science, which I think is very relevant to our conversation about climate on federal public lands today. A systematic interdisciplinary approach to achieve integrated consideration of not just silviculture, not just timber harvest and management, but all of the relevant sciences. And I think you can add to that social sciences as well, because it's as much about managing people and our expectations and our uses as it is about managing the resource. I think if you talk to any federal land manager, they will probably tell you that. Again, just layering upon multiple use, sustained yield, listing some of the things. It's not a mutually exclusive list, but what is it meant to manage for sustained yield? Back up 1 second. Again, coordination of these things, pretty tough balancing act. But with science as the backdrop, and there's another provision related to diversity of plant and animal species across the National Forest System, and planning, systematic planning, utilizing science and interdisciplinary resources and approaches as well. Last one, FLETMA, 1976. This is for the Bureau of Land Management. Same sort of message, but is it succotash? You know, George Cameron Coggins at one point wrote, succotash. Multiple use is just plain succotash. It doesn't really give the agencies any concrete parameters to guide their discretion in managing the federal public lands. But I would say that at least to some extent it does. Because if you add to it the sustained yield component, that now requires agencies to think about climate change and climate resilience and all of the different resources that they manage as impacted by climate. Multiple use sustained yield for the BLM lands, the public lands shall be managed, and this is a longer list than we saw for the Forest Service, but it's also very well grounded in science. And I want to just skip to the bottom here, where appropriate, provide for the public lands to be preserved and protected in their natural condition. Nita Culver talked about 30 by 30 America the Beautiful and the Public Lands Conservation Rule this morning. And I think perhaps those initiatives, in part at least, go directly to this phrase and to continue to provide food and habitat for fish, wildlife, and domestic animals. So one of the questions I think I would like you all to think about, and for us to think about as we talk about climate on federal public lands, is it more or less challenging for the multiple use agencies to address climate change effectively than it is for agencies like the Park Service and its dominant use sister in the federal family, that is the Fish and Wildlife Service? Are they more constrained? Is discretion a good thing, or is it kind of a get out of jail free card when it comes to some of these agencies? So I am going quick with that, just setting the stage with the statutes. Got to have a little bit of law here, right? For those that are seeking CLEs. And I'm going to ask Kathy if you could go ahead and cue up your slide, please. Hello out there in Helena, by the way.
Okay, shall I start?
Go for it.
Okay, well, thank you to the Public Land and Resources Law Review for the invitation to talk to you all. And I'm sorry I can't share the stage with Sandy and Starlin. I have to tell you, it's still snowing in Bozeman as I speak. So this was a bigger storm than people thought. I am the scientist on this panel, and I study climate change in my own research as it happens over long time scales and how it shapes the development of ecosystems. But a few years ago, I realized that the research that I was doing was not having much of an impact outside of the scientific circles that I was presenting it, and that there really was a need to get information to people in Montana and across the region about climate change and to sort of bring the science to people in ways that was useful to them. So there was information at the international level, the IPCC reports, there's information at the national level, but there really isn't good information at the state level or at smaller levels than that. So I worked with teams of people to develop the first climate assessments for Montana. This started out with the 2017 Montana Climate Assessment. We say it was stakeholder-driven, science-informed, because we spent almost a year just talking to stakeholders and tribes around the state to try to understand what their needs were for climate information. Then we developed a special report working with healthcare community, looking at how climate change was impacting human health in Montana. And then in 2021, we tackled the first climate assessment of an ecosystem, and what a grand ecosystem it is. And we produced the Greater Yellowstone Climate Assessment, focusing in on what climate change meant for particular watersheds in the Greater Yellowstone region. Now, these assessments are really efforts to take the best scientific knowledge at the time that they're produced and to put it into language that we hope everyone can understand. We always say we're writing it for 8th grade level, but I think everyone knows there's some really, really smart 8th graders and some really, really dumb adults. So, you know, we're just trying to hit that mark that we think people can use the information and it makes sense to them. Takes a couple of years to do a climate assessment, so it's no small operation. And while we do have hard copies of the assessments, most of this material is available online. And you can't just do an assessment with a couple of scientists in a room. You really need to bring a big group to the table to do it if it's going to have any credibility at all. So for example, the Montana climate assessment was a big partnership. It was the 2 universities that was essential. We had funding from National Science Foundation. It involved federal agencies, USGS, Forest Service. It involved the tribes. We had particular help from Bighorn College faculty and folks at Salish Kootenai College. And it involved, as I said, nonprofits, but also some for-profits. So part of my job in leading these assessments is kind of keeping the train on the tracks and making sure we can get this done and that it goes out for peer review and that it's widely dispersed. There's been some big impacts from having these more local assessments. First of all, it led to the motivation, I think, and the development of the Montana Climate Solutions Plan. This was developed by a committee of about 40 people representing all sectors of the state under Governor Bullock. And it's not been much used in recent years, but I think it's really starting to come to reemerge as a document that needs to be consulted. It also has led to a number of local climate actions and local climate plans in the big cities, I guess the big urban areas around Montana and some of the smaller communities, and some very, very active NGOs who are putting the information out and trying to connect organizations across the state. So they draw heavily on the fact that we have specific information about what's going on in our own backyard. And it was instrumental, I think, in the recent Held versus State of Montana case, the young people suing the state of Montana. And if we hadn't had a Montana climate assessment available that they could bore into and talk about how climate change was impacting their right to a clean and healthful environment, I don't know if the case would have been as successful as it was. So let me turn to public lands now. So this is a big swath of the country. It's 640 million acres. About 28% of the land is in federal public land categories, one thing or another. And most of the lands are in the West. Now, a lot of these lands are sort of chosen and designated because they're located in extreme or interesting locations, right? They're either really low elevations or high elevations, or they're coastal, they're desert, so they go all the way to the Arctic. They're protecting sometimes interesting features of geology or really important parts of biodiversity. So they're chosen as sort of extreme environments in a lot of cases. And so it's no surprise that climate change has been more extreme, I guess, on these public lands than in other places. For example, if you look at the national parks, they've warmed at a much faster rate than the US as a whole. Right now, the national parks in the conterminous 48 states has warmed over 2 degrees Fahrenheit versus the national average of about 1.5. So because of their location, they're really vulnerable to climate change. And that's also true in terms of precipitation. So this is just looking at how the precipitation of particular years compares to the sort of long-term average. And this is looking at 2020. And you can see that most of the area that's getting a lot drier are these public lands in the West, whereas the Eastern US is getting wetter. And there's this sort of dictum in climate science that dry regions tend to get drier with climate change as it gets warmer, and wet areas tend to get wetter. And I think that shows up really sort of clearly in this graph, where the dry and arid parts of the West are getting drier and the Southeast, for example, is getting wetter. And another thing we've seen on public lands is an incredible loss of snowpack. It's measured April 1st. That's the way we compare all the sites to each other. And the circles here are showing you, the size of the circle is showing you the amount of snowpack change from 1955 to 2022. If it's red, there's been a loss of snowpack, and if it's blue, there's been a gain. And you can see that over most of the West, there's somewhere between a 20 to 80% decline in snowpack on our public lands. And this is important because these are the headwaters for most of the West. Most of the headwaters are on public lands. Tree ring studies show that we haven't had snowpack this low in at least 800 years. So we're really moving into uncharted territory. Well, what does climate change mean for public lands, and not only the biodiversity and the water resources on public lands, but also the people who depend on those public lands? And I just wanted to walk you through a few of the things that we should be thinking about. First of all, it's warming, and it's going to get warmer, right? So this is a temperature graph from the Yellowstone Climate Assessment, and it goes from 1900 to the end of the century. The black line is what's the temperature variability for Greater Yellowstone as it's been observed, and the red and blue line are projections into the future. These projections are based on sort of assumptions as to how greenhouse gases will change with different socio and economic and technological decision making. The red line is the extreme case. It's RCP 8.5. It's a scenario for the future that assumes that we really continue to use coal globally as an energy source, and that results in the most dramatic warming. RCP 4.5 is a more intermediate scenario where we start to really back off on fossil fuels, but do it fairly slowly. And most scientists think that we're sort of on that blue line scenario right now, the way things are going. And if we really wanted to get to, 1.5 degrees centigrade, which is kind of the gold standard by the middle of the century, we not only have to reduce fossil fuels, but we'd have to sequester greenhouse gases in some way to bring this curve even farther down. A couple things to notice. First of all, the models do a really good job of matching the observed. So our climate models are really quite good these days. But also notice that as you go into the future, the errors, the shading of pink or light blue around the median value gets broader and broader. And that's based on the uncertainty in those socio-economic decision-making pathways. So as we go into the future, we're actually much less certain about what greenhouse gas contributions are going to look like. Nonetheless, and this is kind of a sobering point for me, is that no matter which pathway we're on, there's not much difference in the projection to the mid-century. In other words, we're on a course of warming to the mid-century that we're probably not going to be able to influence very much by anything that we do now. At the end of the century, depending on the pathway, it'll be 4 to 6 degrees warmer, or something like 10 to 11 degrees Fahrenheit warmer in Yellowstone region. And that's true. Actually, those numbers are true for almost all of the Western national parks as the amount of warming they'll experience. This is another picture from the Yellowstone Climate Assessment, and it's looking at snowpack. So this one goes from 1950 to the end of the century. And the vertical axis is elevation in the Greater Yellowstone region. Blue is the elevation of snow. Green is the elevation of rain, and orange, red, and yellow is that slush kind of snow that we all really hate. And you can see that in 1950, the elevation of snow dominance in Greater Yellowstone was about 7,000 feet. But simply because it's getting warmer, that elevation has been rising so that by the end of the century, it'll be around 10,000 feet. That's not because of how much precipitation we get. It's just that it's warmer, and so we get less snow. And instead, we're getting more rain-snow mix and then more rain. That shift shows up on these maps. Here's the Greater Yellowstone region shown by the black line. And blue is the elevation of snow. So this is the way it looked in 1990. This is 2030, 2050, 27. And you can see that by the end of the century here on the upper right, there's almost no snow because it's warmer. That has impacts for how fast the snow comes off, because it comes off as there's more snow, or sorry, less snow, more rain, and it comes off faster. It also has an impact for glaciers, as you know, and There's 168,000 glaciers in the world, and 2/3 of them are significantly melting. And that's true in our own region. The glaciers in Glacier National Park formed about 5,000 years ago, and they're projected to be functionally gone by the middle of the century. No matter what pathway of warming we're on, we're losing the glaciers. The same in Olympic National Park, the same in North Cascades. Glaciers are really the poster child of climate change in our Western public lands. We're also looking at ecological change. So by this, I mean, we're seeing changes in species abundance, species distribution, species behavior, species sort of phenology or life cycle. And this is directly related to climate change. Anytime in the past we've seen climate change, the ecosystem has to adjust. Species have to move or they'll go extinct, or they have to figure out how they're going to adapt to a new climate. And what we're seeing is wolverines are declining, grizzly bears are on the move, cold water fish have to go to higher and higher elevations to find suitable habitat. Toads and frogs are having a hard time because their wetlands are drying up, and species like our migratory birds are coming in before food sources are available. So no matter what happens, we're going to be living with ecological change as it's playing out on public lands. White bark pine is one of the big stories that we face in our region. It's already declined over 50% of its range as a function of the bark beetle, the white pine blister rust, drought, and fire. In 2022, it's been listed now as a threatened species under the Endangered Species Act. So that's the trees on the left. And then on the right is the Joshua tree. It's declining as well because of drought and fire and land use. And it's thought that by the middle of the century, Joshua Tree National Park may not have any Joshua trees growing in it. There's another study that came out that said 20% of the conifer species in the Sierras no longer live in a climate that's suitable for them. So they're like zombie trees because they can't replace themselves, they can't reproduce, and that's happening in more and more places. We're seeing a big shift because species are changing. We're seeing a big shift in biomes. So forests are moving upslope, and we're seeing a shrinkage of alpine meadows. Shrubland is moving downslope, especially when forests burn. So we're seeing a loss of forests at low elevations. And then there's this huge incursion of forest and shrubland into the Arctic, this increase in tundra greenness. And this has an important feedback to the climate system and tends to make it warmer. Another aspect is living with wildfire. When I started my research, it was during the 1988 fires in Yellowstone, and I thought that was a really big deal. 800,000 acres burned in Yellowstone in 1988, but in 2020, 10 million acres burned in the West. And this year alone, 45 million acres burned in Canada. The amount of fires in Canada this year is staggering. And it's three times the amount of CO2 has been released by those fires as is released by fossil fuels in Canada. So it has a huge feedback. These fires are another thing that really aren't considered in climate models as to their impact on climate change. And there's going to be more very large fires, just looking at the kind of conditions, climate conditions that give rise to fires as we go into the middle of the century. Particularly, you can see that one of the worst areas is going to be in Montana. Not only is it the environment and the biodiversity, but we're losing cultural resources because of climate change. There's significant erosion in our coastal protected lands and in our arid lands that have been subjected to extreme weather events. And so this is another thing to consider as a climate change consequence. And then we're living with more people. And so I think public enjoyment, which is, as Sandy mentioned, a very important part of the public lands mandates is also compromised. In 2015, we had over 4 million people come to Yellowstone, and we've had almost that number every single year since then because people come to the park to get away from where they live, which is too hot or too dry or just, kind of unbearable. And it puts a lot of burden on our resources and on our gateway communities and on our waterways and our backcountry. So living with people is going to be a consequence of climate change in the future. And then there's just the general uncertainty of extreme weather events, less snow, more rain, the snow melts sooner, we go into summer being dry, that puts pressure on agriculture, puts pressure on communities. Living with uncertainty is very much a certainty, thinking about the future of climate change. Now, in terms of management of public lands, managers are very aware of climate change, and they've been trying to develop an adaptive management framework that will give them the sort of lexicon to deal with climate change. So they have agency to take action and think about climate change. This is called the RAD framework. That's the lexicon that's being used now. It means resist, accept, or direct. And so in some places, you may just leave things the way they are or try to restore things the way they were, and basically just observe, but don't really interfere or manage in other ways. Accept is that you kind of sit back and just sort of watch what happens and let that take into account that the environment is changing and climate change is driving changes, and don't do anything to intervene. And direct is when you actually say, well, we can do something about this. We're going to go in and try to change the structure or the function through various actions. So RAD is very much the language that's being used in resource management now. And I think Tom's going to talk about that next. But there's a lot of problems with operationalizing RAD. And I'm myself am rather skeptical of it. First of all, you have to decide the appropriate scale of action that you're going to do this management at. If it's not, climate change is a big scale problem, is a small scale solution going to have any impact? You also need to consider the regulatory constraints of different jurisdictions. Nature lies along gradients. Jurisdictions have usually straight lines. How are we going to make decisions in one federal jurisdiction that might impact another? We just need a lot of baseline information to be smart about operating with RAD. First of all, you need climate projections for the future that are at the right scale and that are really addressing the issues that are of concern. You need to know something about each place that you're going to take active management. What's the history of those places? How has the present landscape been shaped by some events that have happened in the past? And how vulnerable and resilient are the species to taking direct actions? You need regular review and update. This is not something you can just go in and do once. You've got to continually monitor. And so you're setting yourself up for a management scenario that involves monitoring, experimentation, and pilot studies. And, like I said, I'm just not sure the scale of the response is equal to the scale of the problem. So I'll stop there, and thank you.
I'm the public land manager on the panel. I'm Tom Olive. Work for the National Park Service, but I work a lot with partners and other land management agencies. So I've got some examples from other, that are cross-boundary. I mostly now I work to help parks understand climate change science and operationalize it into their management actions. I am with the Intermountain region of the National Park Service, which is 8 states from Montana down to Arizona, New Mexico, even Texas, Oklahoma, 85 parks. And I am mostly going to use examples from the Northern Rockies here. So I want to follow up a little bit with what Sandy started with the hierarchy of law, regulation, policy, and guidance. And Sandy well covered the laws that are enabling legislations for 3 of the 4 federal land management agencies. But we do have, regulations and policy and guidance as well. I wanted to just cover a little bit of that from climate change standpoint. Recently in 2021, we got the executive order on tackling the climate crisis at home and abroad. An executive order to us has the power of a regulation. We also got guidance, the Federal Sustainability Plan, which covers all federal agencies. And then in the Department of the Interior, we have a climate action plan, which covers 3 of the 4 major federal land management agencies, those of us Interior, Park Service, Fish and Wildlife Service, and BLM. And then within the Park Service, we have our management policies, and this is similar to all the agencies. But beyond that, we also have policies dealing with climate change specifically. In our case, we have 3 policies for natural resources, cultural resources, and facilities. And I'll just say that when I first started working in the Park Service, one of my bosses gave me a very succinct and I thought useful explanation of the difference between law and policy. And he said, if you disregard policy, then you'll get a letter to your personnel file. If you break the law, you can go to prison. So I thought that was a good way to kind of think about it and differentiate between the two. But really what people in the field follow is guidance. And in our case, the National Park Service, we have the climate change response strategy. Actually, the updated strategy just came out last month, maybe even this month, earlier this month. And we have 4 cornerstones in that strategy: mitigate, communicate, adapt, and understand. And Kathy talked a lot about understanding, so I'm not going to cover that. I'm really going to focus on adaptation, but I want to talk a little bit about mitigation to start with, because to me, mitigation is mitigation is really turning the spigot of carbon off, and adaptation is just learning to live with whatever we have. And so I think all of us should be thinking about mitigation probably more than I do. I mostly work in adaptation. We in the Park Service have the Green Parks Plan, and we have goals for net zero greenhouse gas emissions, for net zero water use and energy use, waste and sustainable procurement, zero emissions transportation, and then just fostering a sustainability ethic. And actually, we have been making pretty good progress toward those goals. We've reduced building energy use, reduced potable water use, reduced scope 1 and 2 greenhouse gas use associated with our own operations, reduced our fleet-wide average greenhouse gas emissions, and diverted, about 23% currently. We're hoping for 50% of solid waste from landfill. So the folks that work in mitigation have done a fantastic job in my mind. And they're continuing to do really good stuff. I want to kind of follow up on what Kathy said about the RAD framework. And then I want to actually give you some specific examples of how we're trying to respond to climate change using the RAD framework. And I agree with Kathy, there's problems with this framework. And one of the main problems I have with it is that every time I talk to somebody about it, then you end up getting into kind of a discussion about whether you're resisting or directing or accepting. Well, accepting is kind of off on its own, but resisting or directing, and it's kind of unproductive to get in those discussions. But this does give us a way to, I think the best thing about the RAD framework, it gives us a way to get off ground zero of just accepting whatever's going to happen with climate change. I think it gives us some empowerment to actually work on managing the impacts of climate change. So I want to first of all, talk about some projects that we use to resist climate change. And that is typically things like trying to maintain or restore native species. This is some work going on up in Glacier. Dr. Clint Mulfeld from the USGS shared these slides with me. So thanks, Clint. And we're really about up in Gunsight Lake, and there's projects going on in a lot of lakes in Glacier. This is just one of them. They're really trying to restore West Slope cutthroat trout, bull trout, and mountain whitefish. And to do that, they're creating a sort of a fish refuge by getting rid of non-native rainbow trout. Rainbow, browns, brook trout are all kind of naturalized natives, but to protect actual natives, in many cases across the West, we are actually removing those non-native fish and, restocking, restoring populations of native fish. And the other thing that we often can do is predict if these areas are going to be robust to climate change in the future, if they're going to be climate refugia. And so if you can get a kind of a 2-for-1, if you can find a place that's going to be maintain its temperature regime and you can restore native fish there. And that is sort of, to me, the classic resist strategy of trying to maintain native species or restore them, protect them from threats. Here's another project from Glacier, another slide from Clint, another resist project. And this is really trying to maintain a bull trout population in Quartz Lake. And it's but the problem there is lake trout, and lake trout are a problem in many, many lakes across the West. But Glacier contains about a third of the natural lake supporting, bull trout, what are like white bark pine are listed under the Endangered Species Act. And they're being lost at a pretty rapid rate, mainly because of lake trout. And Quartz Lake is a great example of where lake trout control has done a great job of helping to maintain bull trout populations. So again, we're maintaining, restoring a population of native fish. And in this case, again, by removing invasive fish. I want to move on to white bark pine. Kathy mentioned this. And this is an area or a resource in which, in the greater Yellowstone, we're actually trying to direct how white bark pine responds to climate change. And so just a little bit of backstory here. This is a slide from Andy Hansen from MSU back in 2010. He started doing some climate envelope mapping for a lot of tree species in the greater Yellowstone, including white bark pine. Keep your eye on the blue, because this is where white bark pine exists currently, or in 2010. But if you look at where it might exist, given what we know of modeling and what we know of the climate futures here, by the end of the century, quite a bit less blue, right? And in fact, if you're, what Andy's climate envelope models projected was that we would lose down to about 3% of its current range under the highest scenario, which is 8.5. And that's what I'm showing you here. Under the less extreme scenario, 4.5, we would lose down to about 17% of its current range. In either case, doesn't seem very promising. And then as Kathy mentioned, between 2006 and 2010, we lost 80% of the adult trees in the greater Yellowstone to mountain pine beetle. And this was directly related to climate change. And the relationship is that the warmer minimum temperatures, the warmer nighttime temperatures, allowed mountain pine beetle to reproduce, exponentially, if you will, and just killed a lot of trees, a lot of white bark pine in the greater Yellowstone. The glacier ecosystem has the same problem, but it's mostly from blister rust. They've lost about 90% of their old trees. So, I think by 2010, 2012, given what we know about climate, given what we're seeing in the landscape, it really kind of felt like game over. Just accept that this species is less likely to occur on the landscape, over the years than it does now. But frankly, I became convinced, and a lot of people became convinced, that that's not really the case. And partly because if you look at climate envelope models, the sensitivity of upper tree line seems to be to temperature. And we know temperature is going up. However, scientists that study white bark pine, like Bob Keene and Diane Tomback, convinced a lot of us that white bark pine is actually more sensitive to competition than it is to temperature. That given lack of competition, it can live in a lot of places, and that seems to be the case. I lived at Grand Village in Yellowstone for 4 years or so, and there's white bark pine everywhere there. It's just not a dominant tree. It's understory to the lodgepole pine there. So we are trying to direct where we can maintain white bark pine on the landscape by collecting seeds that are rust resistant and also hopefully drought resistant. And trying to put them in places that we think they can survive in the future. And that we're doing some research right now on what those best places might be. So we've got people, collecting seeds, climbing trees. We've got people out, we send them out to be grown in a nursery, and then we also have a lot of folks out there assessing white bark pine and you know, not only in the winter, but in the summer as well. So we're hoping that we can kind of maintain white bark pine in the landscape by directing where it might live in the future. And then just a direct and resist. That's, you know, the Yellowstone floods last year. Many of you maybe tried to go to Yellowstone and couldn't. Big, you know, I think we all know the story. 5 inches of rain came down on June 12th, 13th, and the Beartooths just brought the whole snowpack down into the river. And this is another great story about how climate change amplifies already existing weather patterns. We've had floods before here, but nothing like this. And this really does seem to be a climate amplified flood. And, you know, in the future, we're clearly going to move this road or change it somehow. It can't survive where it is now. But we also, you know, throughout the road system, we may just armor the roads where they are. And I use armor kind of loosely, but just because it's really expensive to build road. I heard that the new road along the old Gardner Stagecoach Road costs about $26 million just to make that usable for temporarily. Okay. And then, you know, accept is probably how we're going to manage quite a few of our resources. Kathy mentioned Glacier. Here's a couple of pictures from Glacier Park. But we just don't have the capacity to manage all resources. And in a lot of cases, management won't influence the outcome. You know, here's a graph of phenology on the Northern Range taken from snowtail sites up at Northeast Entrance. And as you can see, the 0 is kind of the long-term average. And before about 1990, the growing season was short, below the long-term average. But since then, it's been growing. And so we've gained about almost 30 days of growing season, which is huge. But there's nothing we can do about that. So just accepting that outcome. In working with climate change, the group I work with, the Climate Change Response Program, we talk a lot about what brings, you know, about hope, about maintaining hope in the face of what's often dire news. And one of the things that's really bringing me hope right now is that under both the Inflation Reduction Act and the bipartisan infrastructure law, we've got quite a bit new capacity to deal with climate change on the ground. We've got some park-based positions. We've got some really important vulnerability assessments. We have a big chunk going to cultural resources, to the Inventory Monitoring Division for climate-ready monitoring data. And then up in our neck of the woods, we're doing a lot of the white bark pine restoration and arid lands and sagebrush system restoration with the money from IRA and bill. And one of the biggest issues we've had in responding to climate change has been capacity. And this is really hopeful for me that we're now seeing action on the ground because we have new capacity. And a little preview of Starlynn's presentation. She does a great job in her presentation because I've seen it, of putting herself in context. I'm a little embarrassed because I just have a picture of me and my dog, but I do have a family and kids and all that. But here's my contact information if anybody needs to contact me. I'd love to talk to folks about this. All right, thank you.
Hello, everyone. Louis Swin, Starlyn Miller, Nitskiwakian, Sawano, Wishkoshik, Chakomat, and Manewik, Mashik, Omat, Manewik, Askonikan, Mashik, Stockbridge, Muncie, Askonikan, Nonat Awe, Scott Turtleot, Canuck, Mashik, Nakia Awe, Antoinette Turtleot, Namatso Awe, Roger Turtleot, Canuck, Mashik, Noko Awe, K. Richmond Canuck, Namatso Awe, Merton Veely Canuck, Mashik, Noko Awe, Carol Rudin Canuck. Bo Miller Awe and Nanahu. Nikitzak Awe, Miles Applemont, Mashik, Moss Campbell. And Nata Awe, Merrill Blue. I want to acknowledge my ancestors and my Menominee language teachers today at Menominee U. It's a nonprofit on the reservation, and also ask for forgiveness for any mistakes I may have made speaking the Menominee language today as I continue to learn. I'm not a first language speaker, and that's for some really important reasons. My nephew has been in the Menominee Immersion School since he was 6 weeks old. And we're doing our part as a family to support him in learning and revitalizing the Menominee language. Our ancestors hear us when we speak their language, and in that way we honor them. And finally, I also think it's important that this audience hear the language being used to see our resilience as Indigenous people in action, despite generations of assimilation and federal policies meant to eradicate that language. Next, I'll share more about my career credentials, which is something that is more familiar, I think, in this setting. I have a bachelor's of science in education, certificates in American Indian Studies and creative writing, a Juris Doctorate, all from the University of Wisconsin-Madison. I'm a double badger. I have 13 years of public service as a tribal attorney. I served 2 nations. I'm a direct descendant of both of those nations, the Menominee and Stockbridge-Munsee, and I'm a tribal citizen of the Little Shell Chippewa of Montana. I'm currently the TWS NLP Director, Native Lands Partnerships, and I've held that role for about a year now. And I'm going to pause here to address the 2 very different ways of introducing myself that you just experienced. For some, the first part probably looked more like a family scrapbook. Yet it's a very common way of introducing oneself in tribal community, which is based on family relationships. Some add their grandparents, great-grandparents, clans they may be affiliated with, and perhaps their traditional names. Again, the focus on relationships helps others to place you within the community and helps to establish trust. And then there's this slide, which focuses on education and career, a very normal slide again for this setting. And it does the same thing, really. It helps to establish credibility and trust. But you see that there are differences. And we're seeing a demonstration of those differences on how one might show up in the sphere of Native Lands partnerships and conservation. Today's roadmap, I'll be focusing on the Wilderness Society, Native Lands partnerships, and climate change and tribes and hope for a better future. So now that you know me, my family, my education and career, we can just move forward to the next slide. So I work for the Wilderness Society. It's a nonprofit conservation organization, and it's 88 years old. I know a few elders that are that old, and they've seen a lot of things in their lifetime. I think the same can be said for the conservation community. Our mission is to unite people to protect America's wild places. And our vision is a future where people and wild nature flourish together, meeting the challenges of a rapidly changing planet. We have values of trust and collaboration, community and commitment, and solutions and science. A group of visionaries of their time, Aldo Leopold, Robert Marshall, Robert Sterling Yard, Benton McKay, Ernest Oberholzer, Harvey Broom, Bernard Frank, and Harold C. Anderson, formed the Wilderness Society to save some of America's dwindling wildlands. At the time, forests and other public lands are mainly seen as resources for logging, mining, and other development. They set out to conserve the wildest places, and they thought that it was a revolutionary idea. But you will notice in this picture that women are missing from that group, and certainly tribal nations and other marginalized groups. Now remember, again, for their time, the TWS founders and the concept of conserving wilderness was a revolutionary idea. But like many institutions we work in, they were working from a colonialist framework. And the framework stems from the doctrine of discovery, which you heard a little bit about today, the Papal Bull in 1493, to colonize the Americas and its native peoples as subjects. We were seen as less than human, which resulted in belief systems that we have in America, like Manifest Destiny, the Dawes Allotment Act, and Velvet Rope Conservation. Tribal land dispossession was very much a piece of that, and Indigenous peoples' erasure was also a piece of that. There are some great studies about family colonial settlism, also a part of that framework. And I think we need to understand that old methods of conservation and many institutions, including public lands, have benefited from land dispossession of tribal nations and Indigenous people. The public lands we enjoy today directly benefited from that dispossession in order to become the system it is today. And so, folks, if we're not uncomfortable, we're not having the right conversations. Two truths can stand at the same time. The truth that public land systems provide great opportunities for Americans to access nature, and the fact that the federal public land system dispossessed tribal nations and indigenous people and erased them from those places. The story is not dissimilar to the work we do in conservation at TWS, to your work, or to your studies as students, or to our nation's history. And once we learn that history, then we can make better choices going forward. President Lyndon Johnson in 1964 signed the Wilderness Act to create a way for Americans to protect their most natural and unspoiled wildlands for future generations. The act immediately put 9.1 million acres of land into the National Wilderness Preservation System, and it set the framework for decades of wilderness conservation. The bill was written and championed by the Wilderness Society's own Howard Zahniser, and more lands would be later protected under the Antiquities Act and other efforts. What some may argue was overlooked, though, is the further severing of relationships between place, tribal nations, and indigenous peoples, and the concept that to protect something, we need to put a velvet rope around it and limit people's access. And it was mentioned today by a panelist to check out Braiding Sweetgrass. Honestly, this book is a breakthrough, a shift in the paradigm. If you haven't read it from cover to cover, you're doing yourself a disservice. Please check it out. I know Robin Walkimmer was here just recently, and you had to turn people away. And I think that speaks volumes. But again, the point is that while TWS and its founders can be credited with helping to establish a framework for decades of wilderness conservation, another truth can also stand, that there was a cost, and that cost was paid by tribal nations and indigenous people. And it was a cost of land dispossession and erasure. Again, those themes are going to keep coming up. We're going to fast forward, though, to 2016. And, from its founding, we had 111 million acres of wilderness protected through congressional and administrative actions supported and or led by the Wilderness Society. But it was also the first year that we officially launched our commitment to diversity, equity, and inclusion at the Wilderness Society, working to ensure that our work reflects cultures and perspectives of people and communities across our nation, and a commitment to helping all people, regardless of background, be able to know and enjoy our public lands. And while DEI can be an important part of working with some Native Americans and indigenous peoples, it's really important to recognize that tribal nations are sovereign and political entities, and therefore DEI is not always the appropriate framework to work from. 2016 was also the year that the world learned and paid attention to what was happening with the Standing Rock Sioux and the Dakota Access Pipeline, which became a focal point over how the pipeline was analyzed and approved, with tribal citizens and supporters arguing that tribal consultation was not adequate, that the pipeline would jeopardize the primary water source for the reservation, and construction would further damage sacred sites near the lake, violating treaty rights. It was one of the largest gatherings of Native Americans in the nation. And I think it's fair to say that the conservation community began to look at ways to work differently with tribal nations because of the exposure by the media to that gathering. Which brings us to the Native Lands Partnerships Program at the Wilderness Society. In 2018, TWS completed an internal review with an indigenous consultant to focus on ways that we could do better to center tribal nations and indigenous partners in conservation and public lands work. In 2020, our TWS staff developed and our governing council approved a Native Lands Partnerships Framework document for working with tribal nations and indigenous communities to provide guidance for engagement with a wide range of partners locally and nationally. We have 9 position statements to help guide how we engage on policy issues, And those areas of policy are the ones that are most frequently raised by tribes and Indigenous-led organizations. In 2022, I was hired as the first ever director of MLP. And also in 2022, we had a great intern that examined and wrote a Pathways to Land Justice report. We work a lot from documents and reports. I think that happens a lot in conservation organizations. Here's an example of one of the graphics from the report that Ashley Grease wrote. And again, the report focuses on ways that the Wilderness Society can support pathways to land justice, systems work, and restore relationships. TWS has worked purposefully to acknowledge the historic and ongoing injustices perpetrated against Indigenous peoples. And as a result, we continue to respectfully and inclusively work with Indigenous peoples to advance the establishment of trust and respect in our relationships. You can't talk about climate change if you don't have those two ingredients. This includes reckoning with our own history, and we're still doing that hard work. Importantly, these reports and documents remain central to helping our organizations center those priorities that are important to tribes and acknowledge that there's more work to be done at TWS to be a great partner. If you're interested in learning more about this report, we do have an external version that I can share with you, so just contact me. So here, this is some of our priorities, but overall, we have 4 main categories of work coming in the door. It includes organizational work, so supporting staff, growth of organization in relation to building relationships with Native partners. We also have a national focus based on policies, legislation, and media, landscape work, so local solutions and relationships and advocacy, and relationship building with tribal nations and other organizations. We continue to work with Indigenous consultants where appropriate to further our work. Last year, we had an audit of TWS communication by an all Indigenous woman-owned company, Home and Peak Solutions. Fantastic. You need some help, check them out. I can't say enough about them. And I think what they identified for us is a really good example to bring up. We show these landscapes oftentimes with no people in them. There's a love for that across the country. But what it also does is it adds to the erasure and invisibility of Indigenous people, further severing our connection with those spaces. And we're doing the hard work, especially when it comes to women, LGBTQ+, and Indigenous people. We need to work harder. So we're trying to do that work at the Wilderness Society and make sure that we're not adding to that erasure narrative. Excuse me. We continue to focus on supporting meetings with tribal nations on their lands. I think that's important. And then facilitating those meetings with an Indigenous approach. And sometimes that means prayer, that means food. Again, going outside of our comfort bubble and going to their lands and meeting them where they're at. We're really interested in the goal of changing the paradigm so that policy and legislative solutions come from communities and not top down from the Wilderness Society or Washington when it comes to sacred sites and conservation solutions that are Indigenous led. We've looked at the intersection of food sovereignty and public lands and land justice, racist and offensive place names work. Public lands curriculum with an Indigenous perspective. This is all work that's still in progress, but we're committed to it. And again, developing best practices for our staff so we're not burdening tribal nations about how to do engagement appropriately with tribal nations. And that means knowing federal Indian law, history, and policy. So now we know about me, TWS, Native Lands Partnerships Program, and we're going to focus next on climate change. Climate change has its roots in colonialism and dispossession of land of tribal nations and Indigenous people. Again, we're talking about these same concepts in different systems. While tribal nations and Indigenous peoples understand this truth, many people in the dominant society do not. Researchers, however, are now starting to focus on these concepts. and these truths. And so they have studies and reports to support these findings. I don't know why written documents always work with the dominant society internally at TWS, and also like what we're talking about today. So I focus on a few studies that are out there that are important when it comes to climate change and Indigenous peoples. And I'm reminded also of one of my elders at Menominee. We went on a forest tour with a conservation community group. And Mr. Greeno, Jeff Greeno, he's a Menominee forester, lots of Indigenous knowledge. But his thing to us was science is finally catching up with us Menominee people. So research in 2021 entitled Effects of Land Dispossession and Forced Migration on Indigenous Peoples in North America shows that land dispossession and forced migration created the groundwork for contemporary conditions in which Indigenous people in the United States today face greater vulnerabilities to their health and food security, lack of access to culturally appropriate education, and have heightened exposures to contaminants. Older studies have primarily focused on rough estimates of the loss of property as measured in acres, such as the oft-cited figure that 90 million acres of land were lost through the allotment of Indigenous lands under the Dawes Allotment Act. Yet researchers in this study constructed a new data set within the boundaries of the current day United States and found that Indigenous land density and spread has been actually reduced by nearly 99%. And the lands to which tribal nations and Indigenous people were forcibly migrated are more vulnerable to climate change and contain fewer resources. So this is a map from that study. And again, a theme of land dispossession in the doctrine of discovery, capable colonizing the Americas and its native peoples as subjects is a part of this research, which resulted in belief systems like manifest destiny and congressional actions like the Dawes Allotment Act. It's not history, but rather it illuminates the present day experiences of tribal nations who lost 99% of their lands and were forced to migrate to lands that are more vulnerable to climate change and contain fewer resources. Further research in 2021 entitled Indigenizing Climate Policy in Canada, a critical examination of the Pan-Canadian Framework and Net Zero Emissions Roadmap, looked at how climate policies and plans can lead to disproportionate impacts and benefits across different kinds of communities, serving to reinforce and even exacerbate existing structural inequities and injustices. Such is the case in Canada, where researchers argue that climate policy and planning is reproducing settler colonial relations. So it's not that we've gotten past that framework. We're continuing that framework as we're coming up with the solutions today. The research looked at the fact that they're still violating Indigenous rights and systematically excluding Indigenous people from policy making. The researchers' analysis also found that despite these aspirational references to Indigenous people and their inclusion in that planning work, both the Pan-Canadian Framework and the Net Zero Emissions Roadmap fail to uphold the rights to self-determination, free prior informed consent, and conflicted with commitments to reconciliation and healing and nation-to-nation relationship making. Recognizing these limitations, the study identified 6 components for an Indigenous-led climate policy agenda. And they found that climate policy must prioritize the land and emphasize the need to rebalance our relationships with Mother Earth, position Indigenous nations as nations with the inherent rights of self-determination, prioritize Indigenous knowledge systems, advance climate solutions that are interconnected, advance climate solutions that are interdependent, and advance climate solutions that are multidimensional. While this supports the emerging literature on Indigenous-led climate solutions, the researchers stress that these calls offer a starting point, but additional work led by Indigenous people and nations is required to actually breathe life into a true Indigenous-led climate policy. And again, I can hear Mr. Greeno saying the science is finally catching up with us. Recent research in 2022 entitled Recentering Indigenous Knowledge in Climate Change Discourse looked at our dominant narratives of climate change phenomena, such as apocalyptic, doom-centered, crises, despair-based narratives that are happening in dominant discourse. And I'd just like to note that this study, at least one of the researchers, Dr. Lara Jacobs, is a Muscogee citizen. So now we are also helping to do the research as Indigenous people. And that's something that my grandparents did not see in their lifetimes. But I'm having that privilege right now, and we're going to see more of that, and that's a good thing. The research has found that these dominant narratives that I just talked about, apocalyptic, doom-centered, despair-based narratives, they damage us as Indigenous people and tribal nations. They create a system where we're passive victims, and they center on Indigenous vulnerability. The research found that these dominant narratives miss the power and promise of strengthening land rights, centering Indigenous knowledge in climate change discourse, and the possibility of hope, hope in climate change challenges. Researchers found that Indigenous knowledge, Indigenous sentinel networks, that is working between tribes and sharing those knowledges of changing climate, and resistance movements against extractive energy projects demonstrate why Indigenous epistemologies must be central to the efforts that focus on mitigating climate change, as opposed to forcing communities to adapt. But let's be clear, Indigenous people have existed on these lands since time immemorial. And because of that, they know how to live through shifting climates, as tribal nations and Indigenous people have already done this. In doing so, they've accumulated a vast amount of knowledge that we should be paying attention to during this accelerated climate change time period. From research in 2018 entitled Indigenous Impacts on North American Great Plains Fire Regimes of the Past Millennium, it lays out very specific climate adaptation strategies for hunting bison by the Blackfeet Nation and Blackfoot Confederacy during the medieval warming period and the Little Ice Age during the last 1,000 years. So again, the science and research is catching up with Indigenous peoples, and that's a good thing. And folks, in any country, we're experiencing a unique time of historical investment too, of funding of tribal nations and Indigenous communities, the likes of which we've never seen in my grandparents, again, their lifetimes. Under the Biden-Harris administration, there's historical levels of funding that have been made available to support tribes dealing with the impacts of the climate crisis. And with this transformational funding, tribes and tribal organizations are eligible to apply for grants to help safeguard their communities. The grants are available in planning and adaptation categories, and those categories encompass a range of activities affecting many tribes, such as climate adaptation planning, drought measures, wildland fire mitigation, community-driven relocation, managed retreat, protect and place efforts, and ocean and coastal management. The historic funding also advances the Biden administration's Justice 40 initiative, which sets the goal of that 40% of the overall benefits of certain federal investments flow to disadvantaged communities that are marginalized, underserved, or overburdened by pollution and environmental hazards. So yes, tribal nations and Indigenous communities have a huge challenge on their hands with the climate change that's happening right now at its accelerated rate, but they're resilient. They have thousands of years of knowledge, and they now have access to funds to implement Indigenous-led solutions. A lot of work is being done to support these efforts by federal agencies in new and meaningful ways. The DOI, which is the agency tasked with upholding trust responsibilities to foster government-to-government relationship between the federal government and federally recognized American Indian tribes and Alaska Native tribes, is undertaking significant initiatives. And this is in part due to the leadership, okay, 2 minutes, of Secretary Holland. So I'm going to speed through. They're doing a lot of good things. You've heard about America the Beautiful for All. And, you know, consultation isn't perfect, but they are doing some things to try to change it and make it more meaningful and robust. You heard about co-stewardship, co-management. That continues to be a promising avenue to our public lands and Indigenous-led solutions. And let's move forward to the, oh my gosh, 2 minutes and I've got like 5 words left. So I want to focus on a real life example of beauty and success of Indigenous-led climate change initiatives. How this work happens with sovereign nations is important to understand, and understanding how conservation does or does not fit within those Indigenous-led processes is also important to understand. Too often, the conservation communities, NGOs have solutions and they attempt to pitch to tribal nations. And those solutions are generally time sensitive to the Hill and rulemakings. And that's not the way to make meaningful, honest, transparent, and truthful relationships. In fact, we should be showing up with no agenda, listening and learning. And so we have done that work with the Confederated Salish and Kootenai tribes as it relates to their climate adaptation or climate change strategic plan. It started back in 2013 when we had a staffer just show up and say, what can I do to help? They weren't there to say, here's my idea. And I think that's important. CSKT recently passed a resolution in 2022 to update that plan, and we continue to be a part of that process along with many of the tribal departments within the tribal government. You know, I would be remiss to not mention Ann Carlson is leading that work, and she's fantastic as a staff person at TWS and really centers our tribal partners in the work. We provide many pass-through grants to that group to support implementation. So that's something NGOs can be doing. And then not putting strings on it about how they should spend that money. CSKT has so much knowledge. They know how to do it. They have focused on intensive climate smart restoration of their high elevation white bark pine forests in collaboration with the Forest Service, BLM, and Crown Managers Partnership, and supporting high school and Salish and college students in climate programs and trainings and mentoring programs. And they've been super successful as a group because we've secured in that group a lot of funding. $130,000 in 2020, in 21, it was $50,000 to support these climate change efforts and looking at these things. And in 2022, it was about $500,000. And currently they've submitted an America for the Beautiful for All Act application. And so they're waiting on a $3.5 million grant. We hope that we're successful in that. CSKT also creates many educational outreach materials, and that's super important. You heard science is one thing, but if your community doesn't understand it, that's a problem. So you have to be able to digest it, and they do a great job with centering it in their community on concepts and art that makes sense. And they also approach it centering things like tribal sovereignty, treaty rights, self-determination, community, and holistic landscape scales in mind. Okay, just 2 other organizations I'd like to point out that are really helping with climate adaptation planning are the Institute of Tribal Environmental Professionals. Check them out if you have not yet. They're supporting tribes in funding, in conferences, in helping to create knowledge within the community and share that knowledge. They have a conference that's coming up. It's every 2 years. It's a climate conference. This year it's in Anchorage, Alaska. If you can get there, I would go there. It's fantastic. Another one is the Native American Fish and Wildlife Society. Again, they're featuring climate adaptation plans led by tribal nations, and we need to see more of the positive, hopeful stories that are out there. And it's your job to go out there and find those, because we can get swept up in the media and just be gloom and doom and really lend into that apocalyptic narrative, or we can be helpful and we can find examples that are working out there. This is my last slide. So on a personal level, I've been affected by climate change. We routinely, every year, we have a sugar bush camp with my family. You know, we make maple syrup, and we do that the old hard way by collecting with pails individually. We don't have vacuums. We boil it outside. It's a long process. It's a hard process, but we do it as a family, as a community. The work couldn't be done if it was one person. But in 2022, EF1 tornado, which isn't huge, but it was big enough to take down our maple sugar trees. And so we had been harvesting from them for, I don't even know how long, maybe 30 years for our particular family in that area. But that didn't stop us. We grieved, we definitely grieved, but we moved over to a new collective, a community place, trust land, where we all share those resources, and we still collect. Every year, we still do this work. So I think focusing on the collective, another panelist mentioned that, is important. No matter what space we're in, federal public lands, tribal lands, you know, rulemaking, all these systems, if we focus on the collective, which isn't always reinforced, it's mostly individualistic. But if we change that paradigm, we're going to be more successful together, and we can be hopeful about that. Thank you.
All right, thank you all for your patience and your attentiveness. Thank you to all of our speakers. We are a little bit over, and again, hope to have some questions. Our organizers are telling me that we can take one question for the panelists. Perhaps we can direct it at all three of the panelists, but that's not mandatory. So, and then we will take our break, and you can certainly follow up with them either in person during the break or via email for those that are still in Bozeman. So one question, please. Who
I'm really
wants it?
sorry for going over.
The pressure's on. And
I'm wondering if you could each touch briefly on the 30 by 30 initiative and how that's especially addressing the tribal involvement component of it, the international component of it, just sort of what's the leading thoughts on that new initiative from the Biden administration in light of adjusting management measures for public lands.
who wants to start? Sherilyn?
Not me.
No. Tom, would you like to start?
I couldn't quite hear the question. Could you repeat it, please?
Just to talk about the 30 by 30 initiative from the Biden administration and the work you guys are doing in line with that, with climate change and its international implications.
Yeah, I can talk about that a little bit. 30 by 30 has sort of transformed into America the Beautiful. And we don't call it 30 by 30 anymore. I think that name raised red flags with people. But it's basically now an initiative that funds a lot of projects. Particularly in my case, I work both in migration and climate change because a lot of the responses to climate change have to cross boundaries. And states particularly and NGOs have been able to put in for funding under the 30 by 30 initiative for the last 2 years. And a lot of connectivity projects have been funded both back east, things like pollinators and amphibians, but in the West, probably more large ungulates. I don't know the future of it, but certainly has been helpful in the present in funding response to climate change. And again, climate amplifies other issues. And so when we can restore things like wildlife migrations, it's really helpful to do that because it is robust to climate change as a management action.
Kathy, do you want to add to that?
Yeah, I can say it's a grand idea, and it's also funding, as Tom says, a lot of projects, and it's involving a lot of collaboration between nonprofits and federal agencies, state agencies, universities. So that's really good fertile ground to develop going forward. And for myself, I just hope somebody's keeping an eye on the bigger vision and making sure that these individual projects lead to bigger consequences.
Yeah, and I would just add, Kathy, I agree with that, Kathy. If there's a strategy, it's a bottom-up strategy, weaving projects together as opposed to a top-down strategy, putting projects in the context of a grand strategy. I at least I haven't seen that yet.
Just add that,
I don't think that there's one approach in Indian country on 30 by 30. I think a lot of tribes have questions about it. They have questions about co-stewardship, co-management. These are words that are relatively new. I was just talking to Ada about that. And so we should slow down in some aspects and ask what those priorities and needs are for those communities. There are tribes that do ascribe to it as well. And it should be okay for any of those perspectives. But it does seem like information is the biggest priority and need for a lot of communities, tribal communities. And I'd just like to point out on co-management, co-stewardship, we're working on a project with NARF to basically not sell a solution on what those agreements should look like, but provide information about what's out there. Again, these areas of sharing knowledge is what's more important to tribal issues so that they can make the best determination for themselves about what makes sense.
Thank you. So we have three wonderful panelists who are going to talk at this final panel about water. Before we do that, I'm just going to quickly mention that this evening at 6 p.m., the Environmental Law Group for the law school is hosting their annual fundraiser event. So if you are still in town, we would love for you to come. Tickets are $20. It includes dinner. The details are in the whatever you call the brochure picture for the agenda, the conference agenda. It's a free cycles tonight. All of the silent auction fundraising proceeds go to the appellate fees for Healthy State. So it'll be hopefully a wonderful time of music and food. There's a cash bar, and hopefully we can have a lot of attorneys come socialize there afterwards. With that, I want to welcome you all to our final event of the conference. Our last panel is the Just Grab sponsored panel, water panel, titled The Evolution of Water, Imagining a New Future for Aquatic Ecosystems. This panel will discuss how management of water rights and water quality in the Pacific Northwest region has changed over the past few decades, looking particularly at state, national, and tribal governance roles. Our panelists are Elaine Hardy, Watershed Department Manager for the Columbia River Intertribal Commission, Erin Sexton, Senior Biologist at the Flathead Lake Biological Station, who is joining us via Zoom because she also was caught in the winter weather up at Glacier, and who I actually had the privilege of getting to intern with my first year of summer at law school. And last, our last panelist is Ada Montague Steepleton, attorney for the Native American Rights Fund, and our moderator is Professor Michelle Ryan. So please enjoy.
Welcome to our last panel. I always have a water bias with last panel. We're exploring questions today. I thought you might be interested in knowing that all the panels, the titles of them, and what was discussed was planned by the students. These are the topics they were most interested in, and they went out and found excellent perspectives here on these topics. So this one is really like, we think about Charles Wilkinson, whom we've mentioned several times. He coined the phrase, the lords of yesterday, these entrenched systems, legal systems, the prevailing paradigm, as someone said, that sort of set the stage for the way resources are used in the American West, and imagining something different. To quote Monty Mills, my dear friend, who I taught with for many years and was supervisor of the law review, he would say a third way. There's an original way, there's the prevailing paradigm way, what's the third way? And so that's what this panel is really about in the context of how we manage water, and connecting the idea of managing water, which was always sort of a hydraulic question, connecting it to wildlife and fishery. So we're delighted to have Elaine start us out. I'll turn it over to her.
Thank you. I want to introduce myself. Nick Patroy, Ilish Manisha Manakmai, who she operated the game, Main Harvey, Kuwatna, Kameka, Koteka. I would just like to greet each one of you. Good afternoon.
And I'm real thankful to be here today to talk a little bit about what I do in my profession as the watershed manager for the Columbia River Indian Tribal Fish Commission. Some recent what's kind of happening right now within our organization and with the tribes that we represent, the Yakama Nation, the Warm Springs Nation, the Umatilla Nation, and the Discourse. We represent the 4 tribes. And what we're kind of dealing with now is the one issue of many is the Columbia River Treaty. All right. So it's kind of a big issue that the tribes are dealing with, not only the 4 tribes that we represent, but there are many tribes. There are 15 tribes involved in the United States side and 3 First Nation tribes on the Canadian side. So the Columbia River Treaty, was first initiated in 1961, and it was approved and signed into law 1964 with no real end date. And the Columbia River Treaty includes the 3 dams in Canada, which include the Libby Dam, well, not Libby, the Mica Dam, Duncan, and the Side Dam. And the main goals of the Columbia River Treaty include optimizing hydropower and coordinated flood control. And those are the 2 main goals and what is in the current treaty. And the treaty may be terminated within a 10-year notice. An ecosystem function and including fish and wildlife were not included in the original treaty. And here's a map you can see in the Canadian, on the Canadian side, you have these 3 dams and up above. And then on the United States side, there's within the whole Columbia Basin, there's over 250 reservoirs. There's 150 hydroelectric projects in the basin. And then on the main stem, Columbia, there are 18 dams, hydro systems, including the Snake River watershed, which is one of the main tributaries of the Columbia, and then those are managed by the Army Corps of Engineers. And then there are 5 county-owned dams, which are on the main stem in the with the orange color. So on the Canadian side, in regards to the coordinated flood risk management, Canada provides 8.45 million acre feet, which is assured storage in the 3 treaty reservoirs under the coordinated plan. And those are the 3 dams that I mentioned earlier. And then, and in regards to the flood risk management side of the treaty, the U.S. must efficiently use its reservoir storage before it can call upon Canada for additional storage. So the U.S. Position is that it has an obligation that kicks when the flows at the Dalles Dam exceed 450 kCFS. And then the Canadian position in regards to flood risk management is that it has an obligation that does not kick in until the floods exceed 600 kCFS. And there's a kind of a big difference between those in regards to flood management. So the downstream benefits that the Canadian are entitled to is the U.S. has a base system of hydropower dams where Canada built 3 dams under the treaty. And in the Canadian treaty, the reservoirs flow coordinated to optimize hydropower production in the U.S. Canada receives 50% of the downstream benefit. And once again, what was not included in the original treaty, and the tribes were not included in the original treaty as well as local communities, you know, with neglect of incorporating fish passage, was ecosystem function. And under the mutual benefits agreement, the US and Canadian entity have agreed to allocate 1 million acre-feet of water that could be used to support salmon migration and while supporting resident whitefish and trout spawning in BC. An attempt by the US and Canadian entities to implement a regionally developed water budget in the early 1980s was overruled by the Permanent Engineering Board, which was inconsistent with optimizing power generation. Here is a chart of an organizational chart of the parties who were involved with the treaty negotiations, which include the Canadian government, the United States government, and then in the middle under the treaty, you have a permanent engineering board, engineering committee, operating committee, and a hydrometeorological committee. As you see, the tribes and local communities aren't involved in any of these, in any of the original treaty negotiations. And this is a this picture that shows the flows at the Dallas Dam. So in the dark blue, you know, you have the historical observed, in the light blue line, you have good treaty observed. And now with the post-treaty, you have the yellow and also the federal buyout flows, described flows. So, you know, post-treaty, you have the flows that were kind of pushed out early in the year. And then that includes, you know, we have a lower, it shows that we have a lower summer flow, which do have impacts to salmon water temperatures, and, you know, salmon migrate out as juveniles, salmon migrate in, and implications to fish migration. So there were bilateral talks, informal procedural, started in 2018. So far, there's been 18 negotiated rounds between the United States and Canada. And there was a break in 2020 and 2021. And more recently, they've had a recent negotiation meeting in Seattle this month, earlier this month in Seattle, 2023. And the goal is to implement by 2023, but it doesn't look like it at the rate it's still going. So Canada's negotiating position includes continuing the current sharing of downstream power benefits, implementing the treaties called upon flood control provisions, and they want to continue to have greater flexibility managing its 3 treaty reservoirs. And in the Canadian side, they do include the 3 First Nations in, you know, as part of their team. And with that, the First Nation tribes in Canada are, you know, promoting ecosystem values to be involved, you know, included with the treaty, so that, you know, to support their resident species, fish species, but also potentially indigenous fish species into Canada. And Canada believes they are not being adequately compensated for the downstream benefits. On the US side, they want to maintain coordinated hydro power operations, compensating Canada for coordination, secure another term, coordinated flood risk management, modeling scenarios and integrated ecosystem function, So, it's kind of positive that the Canadian side and the United States side want to make an ecosystem function. And including the regional needs for irrigation, municipal and industrial use, stream flows, navigation and recreation. And also included adaptive management to address climate change. So going to call upon creates too much uncertainty for both parties, focusing on securing another term of the coordinated FRM. Calculation was presented a value of 50% of future damages avoided to the US. While continuing to coordinate on power generation, the US proposes paying the value coordination rather than returning the Canadian entitlement, 30 million versus 180 million. Once again, Indigenous nations and tribal roles in this. On the United States side, there's really no seat at the table. There are 15 tribes that are working with the United States negotiating team to present the importance of ecosystem function. And on the Canadian side, they actually have the First Nations have a seat at the table to, include what their priorities are with this negotiation. However, the 15 tribes do have some representation to join the meetings, but I'm not real formal seat at the table with the negotiating teams. Here's a photo or a picture of the Columbia River basin, and on the Canadian side, you can see the different locations of the different bands and tribes. And on the Canadian side, however, if you group them up there, they can be grouped into 3 different First Nation tribes and bands. And then down below, in the United States side, we can see the different tribes that are affected, that could be affected by the Columbia River Treaty updates. In Montana, you have the Kalispell and the Cooney, and then the Yakima, Warm Springs. These are the tribes that we represent, and we continue, to have we have treaty fishing rights all throughout this area, where we still practice, and we still, invest a lot of money, time, and effort into fisheries restoration. We have supplementation programs where we're bringing, raising salmon, steelhead, other species, and it's been a positive. Our work has shown, to improve fish populations in the basin, and we do support the Canadian tribes in returning salmon, above Chief Joseph Dam and Grand Coulee Dam, because the tribes, there as well as here have not had salmon for over 100 years, and it's a tremendous loss to have no salmon back in your watersheds, especially when there is available habitat. So, the Columbia River Treaty, could play an important role in, the mission that the Columbia River tribes are working on to get salmon above these dams that don't have fish passage. The tribes advocate for ecosystem management approach to restore and preserve tribal natural and cultural resources, to restore spring and early summer freshets, which are important for fish migration, out migration, and to help restore the estuary and move fish. To minimize drawdowns at the upper reservoirs and restore fish passage at all historical locations, which are include the United States dams, the Grand Coulee, Chief Joseph dams, and then the three Canadian dams also. The tribes issues with the treaty, there's currently no tribal consultation during negotiation or tribal representation during implementation. Where it was mentioned earlier by the tribes on the United States, I don't really have a seat at the table. They can join the meetings, they can attend workshops with the Canadian and United States negotiators, you know, to talk about reintroducing salmon into the upper watershed and to include ecosystem function, but really on the United States, there, you know, is no real government to government consultation, which there should be, because some of the tribes are treaty tribes and still hold, you know, there's an obligation there. Adopted hydropower and flood control as management goals. This, you know, disregard fisheries altogether with the exclusion of ecosystem function. So flood control plan eliminated during flooding and freshets moved flood upriver, the Grand Coulee and treaty projects built without passage, you know, totally eliminated salmon spawning habitat above those dams. And the benefits of the treaty system are not shared with the tribes. And the tribes' goals for the modern treaty include securing the sea at the table, being involved in treaty review, negotiation, and implementation, to manage the river for ecosystem function, equal with power production and flood risk management, restoring fish passage to the historical habitats, and equitably sharing benefits of the system with equal access to resource development opportunities consistent with ecosystem function. Here's just an example of a reservoir drawdown in the Spokane River on the Washington State side. This is at the Grand Coulee Reservoir. And, you know, it just shows, you know, that, you know, with the dam functioning, how they do their, you know, manage the system, that cultural resources are impacted with, you know, drawdowns such as this. The Pacific Northwest states and tribes support the pursuit of congressional authorization and appropriations for the region-wide public process to assess potential changes to the current level of flood risk protection in the Columbia River Basin to enhance spring and summer flows. Any such process should occur between 2014 and 2024. And, you know, this is the time of the negotiation right now. On this slide, and I'm not sure if this will be properly be shared with the group, but there are additional resources here to look into the Columbia River Treaty, the tribes' positions, and the coordinated flood control operating plan. But, you know, these are good resources to look into. In closing, I just wanted to mention that, as well as with the Columbia River Treaty and the exclusion of the tribes, you know, in the region, there was this Northwest Forest Plan, which was developed in 1994, and the tribes in the states of Washington, Oregon, and California were excluded in this big plan that, you know, covers 17 national forests, which, you know, means the Cascades and Olympic National Forests, 25 million acres. You know, the tribes were not included. And so there's currently an amendment that has fallen into place. And I was chosen to be on the federal advisory committee to serve as one of the 4 tribal representatives to be on this committee. And our focal areas for the amendment include tribal inclusion, climate change, fire resiliency, old growth forest management, and also looking at the affected communities around these forests. And so those are the main areas. And with this amendment, you know, of course, it was realized that the tribes really didn't have a seat at this table also. And, you know, it's important with all the tribes in Washington and California to be, you know, at the table and also promote other tribes to incorporate, you know, what's important to the tribes and what should be included in the next plan. So, on this map here, you can see the 17 forests that I was talking about, national forests. And it's, you know, quite extensive, 24 million acres. We're looking at it at a landscape scale, but this plan is like an umbrella plan over all of these individual national forests. And currently there's myself as a Yakima citizen, there's a select tribal member citizen, a Warren Springs citizen, and a Yurok. So there's 4 of us, and then one attorney for one of the coastal tribes. But you know, we're really working hard, and we're working on the notice of intent, which will be coming out soon. But you know, it's really, I think it's key that this amendment is, you know, happening because the different areas that we're focusing on wasn't really included in the original forest plan, which, you know, climate change is one of the main ones that really needs to be, you know, incorporated. And the reason, I guess one reason I was chosen was to work on the aquatic section, since I have a lot of experience in fisheries and water resource. But I'm also keying in on the communities and representing the tribes. So I think my time is up. Thank you.
We see you and we see your screen.
Oh, wow, amazing. Yeah, I'm really apologetic that I can't be there in person. So thanks for allowing me to give this presentation remotely, and hope it won't be too painful from afar. I can see that you guys can see my screen, so that's an interesting effect. I'm going to continue a bit on the Columbia River Basin theme, but from a different narrative in terms of an area that I have worked on since I was a graduate student at the University of Montana in the early 2000s, which is the issue of mining in transboundary rivers and the challenges that raises both scientifically and then in terms of informing policy and management decisions. And I have my colleague Rich Jansen's information up here as well. Rich is the Department Natural Resource Head for the Confederated Salish and Kootenai tribes, and he and I have worked in partnership on this really since for over a decade, starting back around 2008, 2009. So I'm just gonna roll right into this. So as I said, I work in transboundary rivers and transboundary systems, as I think you just heard, you know, one of the biggest stories of very complicated Columbia River Treaty issues. Transboundary rivers create really interesting management questions. And so this is the Flathead River. I call it the transboundary flathead, but this really natural line down the center of the picture is the US-Canada colonial boundary. And south of the boundary is Glacier National Park and the North Fork Flathead River. We call it the North Fork in Montana. North of the Canada-US boundary, it's called the Flathead River in British Columbia. And if you're a fish in this river, you swim right here across the international boundary, like West Slope cutthroat trout and bull trout do all the time. You're listed under the Endangered Species Act if you're a bull trout in the US, but when you cross the border, you don't have any species status. On the contrary, West Slope cutthroat trout have some listed status north of the border, but were petitioned but not listed south of the border. And you have national park lands over here, provincial crown lands here, which have the focus of their land use have been forestry. These are cut blocks in the background. So you can just see, you can end up with really cross-threaded or at least not complementary land management uses, just depending on which side of the man-made boundary you are on. And so this is another view of the two watersheds that I'll be focusing on today. This is that transboundary flathead that we were just looking at the picture of in orange, and then the transboundary Kootenai system in darker orange. And both of these rivers, they have a lot in common and then a lot of differences in terms of land management. They're both headwaters of the Columbia River system. They're both transboundary rivers, so they cross the Canada-US boundary. Both of them are underlain by high quality coal in their headwaters up here in Canada, which I'll talk more about during this presentation. And then in addition, both of these watersheds lie entirely within the Transboundary Chinook Nation traditional territory. And the current day governance for the nation is that the Confederated Salish and Kootenai tribes are down here in Montana. Akonkami are the Kootenai tribe of Idaho. They're in Bonners Ferry. And then there's 4 bands of the Chinook Nation north of the international boundary. But the nation has brought forth really been the most visionary in terms of solutions on some of the problems I'm going to discuss, because they already operate in this as one connected transboundary landscape and connected rivers. And so I first came to work on this in the early 2000s when there was a mine proposed in the headwaters of the Flathead River. And this is the location of the proposed mine. There was also mines proposed right underneath the river in the center of the floodplain. And as you can see from the photo, this is the British Columbia portion of the Flathead. It's unsettled, so there's no permanent human residence in there, and there are no active operating mines anywhere in the entire transboundary Flathead, or there were not at this time. And so, as I said, when the mine was proposed, one of the first things that came to mind for both the tribe, the Confederated Salish and Kootenai tribe, and also all of our state and federal entities south of the border were questions around impacts to our transboundary bull trout populations. They migrate regularly from Flathead Lake up across the international boundary and spawn in the headwaters up here, and then travel back down to Flathead Lake as part of their life history. And so that was one of the biggest concerns raised when the mine was proposed, was what would the impacts be to our listed bull trout populations, and stemming from mine impacts to water quality and habitat that could negatively impact bull trout. And that's not the first time that this had been asked. So, and sorry, I can see that some of my stuff is cut off on the slides, but the International Joint Commission is a Canada-US body that came to be in the early 1900s when the US and Canada signed a Boundary Waters Treaty of 1909. And this commission is meant to be an arbitrary body that oversees the boundary waters between the US and Canada. And there's three commissioners appointed from the Canadian government and 3 commissioners appointed from the US government. And together those 6 commissioners present an objective body for overlooking boundary waters boundary waters in the US and Canada. And so this commission was asked to intervene on the Flathead River in the late 1980s when there was a mine proposed in the Flathead, as there was again in 2003. And the IJC is the acronym. They're not a legally binding entity, so they made recommendations, but their recommendations aren't can't be legally implemented. They don't have regulatory authority across the boundary, but they did say that the mine proposed in the 80s would violate the Boundary Waters Treaty, Article 4, which says that waters flowing across the boundary shall not be polluted on either side to the injury of health or property of another. And they were particularly concerned about impacts to the bull trout fishery in the transboundary Flathead River. And so when the mine was proposed in 2003, it was a bit of a Groundhog Day for at least lots of people who had been around in the late 80s when the first mine was proposed. And same concerns. So, you know, basically you have an interesting regulatory situation where the permitting of the mines takes place in Canada through the provincial regulatory system. But the contamination and environmental impacts of the mine, because of the way water works, would be carried possibly across the international boundary and down into the entire Flathead Basin and into all these jurisdictions, including the Confederated Salish and Kootenai tribes reservation land, but also their tribal territory. And so we wanted to better understand what the impacts of those mines would be, the proposed mine in the Flathead. So this is another map. Here's the BC Flathead River, and here's the Elk Valley. The Elk Valley is a tributary of the Kootenai system. This is the Elk River, and it flows into this international man-made reservoir, Kootenai Reservoir, which was on Elaine's slide that she showed previously, where you could see Libby Dam. Libby Dam impounds Kootenai Reservoir. And so we were curious about impacts from the proposed mines in the Flathead. So we decided to go into the Elk Valley and look at what types of impacts the Elk Valley mines were having on the Elk River and use that to inform what might happen in the Flathead. And this is the two watersheds. So this is literally just the watershed divide between the two rivers. And here you can see the Elk these are open pit coal mines that run from north to south in the Elk River. There's 5 of them. And then this is the Flathead again at the international boundary right here. And so just to put a little more emphasis on the size of the Elk Valley mines. So this is a map of the province of British Columbia. Down here in the far corner is the area that I've been zooming in on for you. And although it's this tiny little corner of the province of British Columbia, this is one of the world's largest sources of metallurgical coal. It's a globally relevant supply, one of the largest exporters of metallurgical coal. And you can see almost 22 million tons exported in 2022. And this is what the mines look like from the air. They're mountaintop removal coal mines. And so the way that you get at the coal is you dynamite away the mountaintop to access the coal seams. And then you deposit the waste rock in the adjacent river valleys, which are really hard to see in this picture because they've all been mined and then had waste rock dumps deposited into them. And so this is the law conference. I'm not going to go into too much detail on the science side of things, but I just want to highlight a few things because, as I said, we were very interested in water quality impacts and those ramifications of those impacts to bull trout and whistle cutthroat trout populations. So we spent about 5 years doing water quality data collection, fish data collection, and then also looking at aquatic life, both in the Flathead River pictured here for a non-mined baseline to see, what the pre-mining condition of the river was. And then also we looked in the Elk River. And so I'm just going to give a few snapshots of data just to give you an idea that we saw very different things in the Elk than we did in the Flathead. And so on the left side of this is the Elk River sites above the mines, and below, and then to the right are the Elk River sites below the mines throughout the river. And this is just to show you these are nitrates. So nitrates were thousands of times higher in the Elk River than they were in the above the mines. And so to us that would give us an idea of what to expect in the Flathead. We also took Flathead River baseline data, and it looked very similar to the Elk River Basin above the mines. Another one of the contaminants that is draining from the mines in the Elk Valley is selenium. It is present in the geology, and it becomes mobilized in the river when the mines go into operation, are excavated and then go into operation. And so again, you can see that selenium is very low above the mines and much higher below the 5 mines in the Elk Valley. And then there's a lot of data behind a lot of these results, but I just wanted to highlight that we also saw impacts to aquatic life. And so these are stoneflies and mayflies and caddisflies. They all are really important food source for the trout, native trout in the Flathead and Elk Rivers. And so we saw both a loss of diversity, so species that were more sensitive to pollution were far less abundant or even absent completely in the Elk River. And then in the Flathead, we saw a really rich and abundant population of aquatic macroinvertebrates across all species and each of these types of aquatic insects. And so I don't expect you to read this, but this is where how things were concluded as far as the proposed mining in the Flathead. So the results that we got from the impacts to the Elk Valley and potential impacts to the Flathead Valley we communicated them with many partners and delivered them to decision makers. And ultimately enough pressure was brought to bear on British Columbia and Montana, the leadership at the time, that they ended up signing an MOU. And I think this is also a really interesting construct from a legal perspective. This is a non-legally binding agreement that was signed between the Premier of British Columbia and the Governor of Montana, Schweitzer, at the time. And all it says, it's just a page and a half, and it says, we'll work together across our shared boundary in the Flathead River on environmental decision making. And another interesting piece of this is that you'll see down here, or you can't see, but I'll tell you what it says, is that it was witnessed by the chairwoman of the Ktunaxa Nation Council, who is actually still the spokesperson, Catherine Tenise, and then the chairman of Confederated Salish and Kootenai tribes at the time, Michael Kenmile. And so it was witnessed by leadership of the nation, although they don't have a direct role in this MOU except for the witnessing. But it did actually say something very specific about mining in the Flathead. And so one sentence in there basically says that mining, oil and gas development, and coal bed methane will not be permitted in BC's Flathead Valley. And the province of BC passed legislation following this declaration that permanently banned oil and gas and mining in the Flathead. And then Montana did the exact same thing. They passed, Senators Baucus and Tester passed the North Fork Preservation Act in Congress, which also protected the North Fork of the Flathead from oil and gas and mining. But we had, I'm just going to finish with some thoughts on the Elk River and the Kootenai system. We discovered a pretty significant pollution issue in the Kootenai system when we started sampling in the Elk Valley in the mid-2000s. And just to show you, this is a water quality trend for nitrates in the Elk River just above the US-Canada boundary in Kootenai Reservoir. And this is the exact type of water quality trend you don't want to see for clean water. You can see that the nitrates started increasing in the 80s and 90s, and then we have this exponential trend, which corresponds to the blasting for the mines. There was a lot of accelerated mining development in the Elk Valley at this time. And likewise for selenium, this is the same water monitoring site, but just for a different parameter in the water. And you can again see this exponential trend. And I use this map to show a few things. And one of those is the regulatory regime of the province of British Columbia. So This line here, this 2 micrograms per liter, that's the provincial threshold for protection of aquatic life. So it would be similar to a US water quality standard, but it's not legally enforceable. So they call it a water quality objective. And so 2 is what is considered healthy for fish and for the river in BC. And you can see here in the early 90s, selenium started passing that threshold and then continued upwards. And the reason I circled 2014 is because in 2014, the province of BC granted an expansion permit for all 5 of the open pit coal mines in the Elk Valley. And so despite this very clear, very bad water quality trend for this contaminant and the fact that they're well above their threshold, the province permitted expansion for all 5 of the mines in the Elk Valley. And they did that with a ministerial order. And the order stated that the mining company, Teck Coal, needed to stabilize and reverse the contaminant trends in the watershed. And these are the list of contaminants that they highlighted to first stabilize and then reverse in the river. And so the mining company's answer to being able to mitigate, to stabilize and reverse those trends was what's called active wastewater treatment. And they proposed to build up to 16 of these wastewater treatment plants throughout the watershed over just over 15 years to stabilize and reverse these trends. And they're multi-million-dollar treatment plants. And the first one was supposed to be built in 2013 to go online then. And unfortunately, there's been a series of problems over time with the wastewater treatment plants. They just have not performed as expected. They were never proven at the scale of the mines before they were implemented. And so for one thing, they are not treating the volume of water anticipated. So they're treating about anywhere between 5 and 10% of the contaminants in the river currently. They had issues. They had a fish kill downstream when they first turned it on. And so then had to decommission the plant, fix the problem, and then turn it back on. And then at one point they were converting selenium to a more toxic form. So even though it was decreasing in the water column, it was actually more toxic to fish and aquatic life. And so there's just been not great success with the mitigations that were put in place to expand the mines, and they're still working on this. These are just some of the news stories that were coming around 2014 about the failings of these wastewater treatment plants. And then here I fast forward to the last couple of years just to show that this problem really hasn't gone anywhere, and it's only gotten worse over the last decade. And really, the Transboundary Ktunaxa Nation are the ones that have put forth both the problem and the solution in front of both the US and Canadian governments. I'm going to end just by talking a little bit about that. Just got Hannah's 2-minute warning. For one thing, where we are today is that we have mine contaminants that are being transported hundreds of kilometers down this watershed. So here's the mines. You can detect selenium increasing and the other contaminants in the Kootenai Reservoir, in the Kootenai River in Montana, in the Kootenai River in Idaho. And you can even see the trend back here where the river crosses back into British Columbia and at the Kootenai Lake outlet. In addition to that, we have one water body, Kootenai Reservoir, that has 2 different water quality thresholds for the exact same contaminant. So the US Clean Water Act approved standard for selenium in Kootenai Reservoir is 0.8 micrograms per liter. The province of British Columbia's number is 2 micrograms per liter. So you have literally, depending on which side of this line you are in the reservoir, you have 2 different water quality thresholds for one contaminant. The position of the Ktunaxa Nation is that the Boundary Waters Treaty is being violated in Kootenai Reservoir because we are exceeding that 0.8 micrograms per liter right now. The current levels in the reservoir are between 1.5 and 2 micrograms per liter. We have this situation where management of these mines is taking place through the province of British Columbia, but there's 8 impacted governments to this issue that are all outside of the current decision-making process, except for the province of BC and the government of Canada. And so we have these impacts that are outside the decision-making framework. And these are some of the solution points that the nation have pointed out. We need to solve the existing contaminant problem and the leaching into the future as well, but there's also the need for accountability for damages to date. These mines have been in operation for over 100 years. And the only case where there's precedent for this in a transboundary situation is where the Colville tribes are bringing a Canadian mining company to liability for damages on their lands. And this is the Trail Smelter. It's owned by Teck Cominco, and it's right on the Canada-US border. And it delivered knowingly directed slag onto Colville lands and waters for decades. And so this is an ongoing case. In addition, the Transboundary Chinohan Nation is working with transboundary nations from other watersheds in northwestern North America. So the transboundary Taku River Tlingit Nation up here, nations in the Stikine, the upper and lower Similkameen Indian bands, and sort of throughout these watersheds, there's a lot of learning and information sharing going on. This is just a summary of the requests that the Chinohan Nation have put in front of the governments. They've asked for an International Joint Commission reference on the watershed that would include accountability for past damages, an assessment of cumulative rather than piecemeal impacts, a holistic watershed approach at the scale of the watershed rather than these little jurisdictional sections, and then again, inclusivity for all impacted governments. And this issue reached the highest levels of the US and Canadian federal governments, brought to them by the Transboundary Chinohan Nation. And at that point, the President and Prime Minister made a commitment to work in partnership with the nation to seek a solution to the issue of mines in the Kootenay watershed. So I will just say, not only is this a big intractable issue, but it's also a great issue for an internship. So this will be my 6th year of a partnership with the Flathead Lake Biological Station and the UM School of Law. And I get one law student for 8 weeks each year to work with me on sort of the policy side of this issue and see the science that goes into it. So thank you very much for your time, and I really appreciate being able to speak to you from afar.
Thank you. Thank you so much, Erin.
Hi, everybody. Hopefully you have a little bit more space in your brains for a little more information. Basically, the text you can't see on the slide, so but I wanted to point out we talked a little bit the international issues on the Columbia River, and I thought it might be helpful to think a little bit about some of the state role that can assist, or that we've seen examples anyway within our area here, assist with ecological solutions. So what you can't read here, it says an unexpected solution that can be found through the state water right compact process here in North County. So here's what I'll cover in the next 15 minutes. Why is it important to think about state roles in the realm of federal reserving and water rights? It'll help you better understand U.S. water policy generally. What are federal reserving and water rights? We'll talk about the seminal case, Winters v. U.S. How can states recognize these rights? We'll look at the Montana example of the compact condition and how it played out through the CSKT compact, which is unique given Stevens Treaty and stream flows that treaty allowed for the right, tribes to retain. And then what kind of ecosystem benefits resulted. So we'll get one example of the Milltown water rights. So first of all, why is this important? I don't know if anybody here can tell me where this picture is taken. Maybe that text is big enough for you to be able to see. But hopefully you can recognize Mount Jumbo there in the background. And here in 1860 or thereabout, we see a very different population of folks living here. We are, of course, as we recognized at the beginning of the conference, on lands that were originally inhabited by the Bitterroot, Salish, and Morai, and Kubi peoples, and they are here since time immemorial. And they lived in relationship with the land and the water. And according to the Salish Penroy Culture Committee, at the center of tribal cultures lay a deeply ingrained ethic of reciprocity between people and the land. And thank you very much to Professor Ryan for her scholarship that captured these words. So in 1997, the Western Water Policy Review Advisory Committee identified that tribal water needs are often neglected despite the legal and moral obligations that underpin them. And I want to call your attention to the recent Supreme Court decision that was touched on also a little bit today, but that's the U.S. v. Navajo decision that came out in June. And it highlights really severely the important role that states play in enforcing and managing Federal Reserve Indian water rights. Last week, the High Country News, unfortunately that's a little hard to read there, reported on documents that were filed by various states in the 1950s as the adjudication of the main stem of the Colorado was starting to ramp up in the case Arizona v. California, which ultimately adjudicated the main stem water rights on the Colorado River. Those documents show that the states involved in the case blatantly sought to downplay and exclude the Federal Reserve Indian water rights at issue in that basin. And today, we continue to deal with the consequences of that action by the states. The overappropriation of the Colorado River is one of the crises that our generation is going to have to deal with. As you can see, over 16 million jobs rely on this water source alone. So it will have long-ranging impacts. I guess my point here is just that states play a big role, and it's important to pay attention to prior rights as states make decisions about how to appropriate water. Here is the Western Union. I got permission from the High Country News to share this. This is a photo of one of the documents that they unearthed in their investigation into the efforts by the states to downplay tribal reserve water rights on the Colorado. So thinking more broadly at the federal level, what is the United States approach to water policy generally? Well, in 1973, the National Water Commission explained that Congress hasn't really done much since the 1965 Water Resources Planning Act in a really comprehensive way. Instead, water policy largely has evolved through executive and judicial actions and piecemeal legislation. And the 1973 report recommended that states create a process by which Federal Reserve Indian water rights could be recognized. And since then, one state has formally followed that direction, and that's Montana. We'll table that thought for a moment while we talk a little bit. Oh, bummer. The slides didn't work out so well for me. Oh, lesson to not rely on your PowerPoint, right? Anyway, Federal Reserve Indian water rights, what are they? So here we have the justice of the Supreme Court who wrote the decision in 1908. And Joseph McKenna, and what he recognized in the seminal case, Winters v. United States, which happened right here in Montana, relating to the Federal Reserve Indian water rights of the Fort Belknap Reservation, is that without a recognition of an implied water right, the treaties, the language in the treaties really they don't amount to much. Basically that decision has held up since it has stood the test of time, sorry. So in the 115 years since the Winters v. United States decision occurred, it's only been solidified and internalized by the executive and legislative decisions that have come out related to Federal Reserve Indian water rights. The point here being that it is tried and true law that Federal Reserve Indian water rights are a reality that every state must take into account. They are part of the bedrock law that we all stand on here. But oftentimes we don't see them play out in reality. However, in Montana, the Compact Commission was formed to address these rights head on. So in 1952, the McCarran Amendment gave state courts the jurisdiction to adjudicate Federal Reserve water rights, including Federal Reserve Indian water rights. And in Montana, like most other Western states, they sought to establish basin-wide adjudications to address the competing water claims within the state. However, as a result of the Bighorn adjudication in Wyoming, which adjudicated the winters rights of the Wind River Reservation, tribes in Montana were really concerned about how statewide adjudication would affect their rights. And so they sought to have a negotiation process stood up alongside the water court. So in Senate Bill 76 that created the Montana Water Court, there also was created a Montana Water Right Compact Commission. And the duty of that Compact Commission was to conclude compacts for the equitable division and apportionment of water between tribes, the state, and the federal government. It was a joint subcommittee of the Montana legislature with 9 members, 4 from the legislature with equal representation between minority and majority, 4 appointed by the governor, and 1 appointed by the attorney general. They initiated proceedings by serving a written notice upon the tribes and the federal government, requesting that they designate representatives to negotiate. And prior, the tribes in this state had already filed their water right claims within the water court. And so those were stayed while the Compact Commission resolved through this compacting process. At the end of each compact, the water court then takes on the responsibility to review that compact and make sure that it was fair, reasonable, and adequate to all concerned. Otherwise, the water court does not have the right to modify the compacts. So there's some advantages to the compacting process. There's a recognition of some of the most important water rights of the interest at the table, an ability to incorporate funding for infrastructure, ability to craft shared water governance structures to enforce water use of both Indian and non-Indian water users, and allow more flexible response systems, particularly in this day and age with impacts from climate change. And also an ability to creatively resolve related issues related to water, but maybe not addressed specifically in an adjudication proceeding. So here we have, this is Chris Tweeten here, talking at a public meeting up in Kalispell during the CSKT compact negotiations and rollout. The compact process, just really quickly in a nutshell, there's the negotiations that occur, goes to the full, or went to the full Montana Water Compact Commission, and then it's sought to be ratified by the Montana legislature. Then because they're both federally reserved Indian water rights and federal reserve rights for other types of land reservations, federal compacts would go through a US DOJ process. Tribal compacts, on the other hand, would go to Congress. Once approved there, it would go to the tribe for approval. Then it goes to the water court, as I was just describing. And then the decree issued and it's ready to be implemented. So let's look a little bit at the CSKT compact specifically. Now, this is a topic that's been the subject of a lot of research and writing. It's really hard to cover in just a few moments. So if you guys have time and are interested in this topic, I highly recommend you go to this web link that you can't read, but I understand might be available to you after when they send the slides out. It's a great interview on Common Ground by Brian Kahn of Melissa Hornbein, who represented the Montana Reserve Water Rights Compact, and just speaks so eloquently on the topic. Anyway, as you can see from this map that I got from the Montana Free Press, these are all the water right claims that the CSKT had the ability to file in the water court when they first initiated their process. Now, the reason that, as you can see from this black line right here, this is the reservation, that so many of these water right claims are off the reservation is due to the special nature of the treaty that the CSKT entered into. So in 1855, the Hellgate Treaty, which is a Stevens Treaty, the tribes agreed to reserve to themselves the right to hunt and fish in all usual and ancestral lands. And the Ninth Circuit interpreted that Stevens Treaty right to guarantee an implied time immemorial water right for in-stream flows to support the fishery. And SCOTUS has held that such language creates an off-reservation right, imposing a servitude on every piece of ceded land. And that's from a case that actually predates Winters. That's the Winans or Winans case, I think it's Winans, from 1905. Anyway, so as a result of these two legal elements, the CSKT retained the exclusive right for taking fish in all streams running through and bordering the reservation and in all usual and accustomed places off the reservation. And that language was really key, and it gave them an extremely strong negotiating position. But what's really remarkable about the CSKT compact is how foresighted the tribes were in negotiating. They had all these important rights and ability to make call on water rights throughout the state as far as billings and beyond even. And yet, instead of taking advantage of that in a full, like, shark-like way that most lawyers are trained to think like, they thought about the reciprocity of working with neighbors and making sure that there was enough water in the streams for fish, but also for agriculturalists to be able to survive and continue their ways of being on this land. It was truly a neighbor to neighbor type of thinking process that they brought to the compacting negotiations. And one of the quotes that stood out to me as I was researching for this was that it was actually something that Professor Bryan wrote in her article that I relied on heavily in putting my thoughts together on this, which is that when we perceive nature as a resource to be exploited, we create overtopped landscapes that leave little for future generations, entrenched degradation that is costly and time-consuming to recover from, and little resiliency to adapt to the climatic changes we are confronting. However, a more reciprocal perspective appears to be a way forward in creating better outcomes. So let's talk a little bit about that. Again, I apologize for my poor choice of using white as the background in my slides. So the Milltown water rights are a really unique situation that could only be thought about in a compact negotiation process. Here you have the Milltown Dam, which maybe some of you are not familiar with, but used to sit right over here on the Clark Fork River. And this dam was, it backed up behind it. Right after it was built, there was a huge flood, like 200-year flood that came through and washed all these tailings from copper mine at that time down and backed it up against the Milltown Dam. So here you have all these tailings piled up behind here. It created a huge environmental disaster, essentially waiting to be addressed in some form. So everybody knew that the Milltown Dam had to come out. As a result of that decision, there were water rates associated, in-stream flow water rates that would go up for grabs, essentially. Happens to be someone was really smart and thought, what if we allow for that water rate, it was one water rate, to be co-owned between the tribes and the state. And so sure enough, that came to be as a result of the compact process. Now the Milltown water rate has been split into two separate water rates. Here you can see the water rate number it was before and what it got turned into. It was before hydropower generation, now it's for in-stream flow habitat. There it's parsed between the Clark Fork and the Blackfoot. And then it has some unique enforcement provisions here. One of the terms of the compact when it came to the Milltown right was that they would not make call on this particular water rate until 2025. That's in 2 years. So what they've been working on since then is to develop a way to roll this out and implement it. So the ecosystem benefits are essentially a way to allow for clean, copious water, cold water to support the complex systems of the Clark Fork River. The Upper Clark Fork, I'm really sorry, these slides are so horrible. So too bad. So the upper Clark Fork is running red in this picture, and that's from the photo from the 1970s. This particular picture shows just how incredibly damaging the mining that occurred upstream of this water system was, and it created a dead zone in this river for, I think it's over 50 years. There was nothing living there, and maybe someone can verify that for me. Anyway, so the ability to make call and allow for in-stream flow to be available on the Clark Fork and Blackfoot rivers today will address some of these long-standing effects from such a long period of extreme degradation. Can't see any of my thanks, but I really wanted to thank everyone that put this conference on. I also wanted to thank the CSKT who gave me permission to talk about the mealtime rights with you guys. Also, thanks to FWP and DNRC for all the information they have out there. And thank you also to Michelle Bryan, Professor Bryan, for all of this. Thank you so much.
We're trying really hard and on time. Your time is valuable, we know. I thought I would just ask all three of the panelists one question to kind of wrap things up. And that is because the panel is called Imagining a different future, a better future for aquatic ecosystems. What would you change about the law that would move the needle to making law better protect aquatic ecosystems based on your own experiences? Erin, you want to start us off? What would you change?
Well, if I could change one thing, especially after all that we've been learning about today, I would make sure that there's better tribal representation at all levels of government and in the decision-making that goes into natural resource management.
And Elaine, you've been making inroads in that particular area of representation, but also saying it's not robust enough. And you're seeing a comparison to Canada. Any ideas of how you would make representation more robust?
Well, I previously worked for the Arca Nation for 20 years, and then I recently took this position at Quebec in June. One of the main things that we come across is the lack of true tribal government to government consultation. And, that's what we're seeing with the Columbia River Treaty, previously with the Northwest Forest Plan, and then even that individual forest, U.S. Forest Service lands, where it's an ongoing theme. And, just having that respect to have that actual government to government relationship with the tribes, whether it be at the state or federal levels, really important. And right now in our area is the renewable energy movement that's happening. And there are over 40 solar projects proposed and in construction on the Arca-Mesita lands. And we are not being consulted on many of them. And we're not included in the signing process of those. And there's still a lack of rightful consultation with the tribes. And inclusion, like she mentioned, the tribes being at the table is really important. And including, the protection of our treaty rights that we retained in the 1800s as our ancestors signed those treaties.
Hey, Erin, last words. What would you change? You focused on transboundary, the challenges there.
Yeah, I think reimagined governance systems that actually follow both the, in the case where I am spending most of my time, both the transboundary governance systems of the nations, which are, families across the international boundary, and also governance that follows the ecology of the landscape, both the, sort of the cultural history of the landscape and the current ecology, and that, we aren't fragmented across these boundaries. And the other piece that I think has been really challenging is that the legal system tends to be reactive rather than proactive. And so it's very difficult to get out in front of management in a way that's protective. Instead, we oftentimes have to have damages and consequences and then try to figure out how to retroactively get accountability for those things. So I'd say more future looking, and yes, on the governance frameworks that are inclusive and follow the ecology of the landscape.
Thank you. Thank you all for being with us today also. All of our speakers would welcome email contacts. They're easy to find online, and you've got 2 in-person speakers you can chat with more. Now that we've wrapped up, safe travels back to your homes. Thank you.